Can I welcome everyone present here today or joining us over the internet for what is the third hearing of the Committee's 2024 review of the Dust Diseases Scheme. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today, and I pay respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Greg Donnelly and I'm the Chair of the Committee. Can I commence by asking everyone, if they're not done so, to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness to inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome and I give thanks to the first witness joining us today, Mr. Martin Smith. And what I'll be doing with yourself and the following witnesses is to invite them to take an oath or affirmation, and in doing so to identify themselves, their name and the position they hold. So perhaps if we commence by welcome Mr. Smith and invite you to take the oath or affirmation.
Thank you. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Mr. Smith, and welcome to the hearing today. I'll commence by inviting you to make an opening statement, and then if you're comfortable, we'll share the next up to half hour sharing questions between ourselves. And as I indicated to you previously, there's members of the opposition, the crossbench and the government. So I invite you to make an opening statement.
Thank you. And thank you to the committee for the invitation to address this inquiry. This is a very important issue for our people and the construction industry. My name is Martin Smith and I'm here in the capacity of Group General Manager, Health, Sustainability and Climate for John Holland. I'm responsible for overseeing the development and implementation of John Holland's health and safety management system and processes, including managing the risks around silica on our tunnelling projects. At John Holland, we are fully committed to the health, safety and wellbeing of our people and contractors, and we take all risks associated with tunnelling work seriously and comply with all the relevant workplace health and safety regulations. I have been following the proceedings of the committee and want to take the opportunity to briefly address some issues raised through the course of the proceedings, after which I'm more than happy to answer any questions. The first is the distinction between a workplace standard exceedance and individual exposure. Whilst it's important to note that an exceedance does not necessarily mean workers have been exposed, we take both extremely seriously, as does our workplace regulator, Comcare. When planning to identify and control the variety of high-risk activities on our sites, we look firstly to how we can eliminate the hazard. If this is not possible, we then work our way down the hierarchy of controls, employing controls consisting of engineering, substitution, isolation, training, and personal protective equipment. This method is also applied to the identification and control of respirable crystalline silica, where we aim to eliminate the generation of silica dust at its source and employ ventilation systems, water suppression, sealed enclosed plant cabins, all designed to minimise the level of silica in the air and reduce exposure. The use of specialised PPE, including VersaFlow masks, is the last line of defence and is never used in isolation of other higher order levels of control. We ensure workers are trained in how to properly fit and wear their PPE. All levels of control have improved in their levels of effectiveness over the years, and they continue to do so. I want to address some commentary about access to air quality monitoring data on our sites. We provide de-identified results of all air quality monitoring, as well as actions and recommendations to workers via site notice boards and toolbox tools, which happen at the beginning of shifts. This information is shared with union representatives, and we also work directly with impacted people if there has been an issue. In addition to sharing information with our workforce, we also provide our results, including any exceedances, to our clients and regulators. I'm aware the committee has discussed the release of air monitoring results for tunnelling projects under a Freedom of Information request. During this process, and as part of a joint venture, we raised objections to the release of this information to an external third party. At John Holland, we have revisited this position, and subject to appropriate privacy provisions, we would not object to the release of this information again. We are ready to work collaboratively with the government and regulators in the event they decide that more information should be made publicly available. The control of silica is a challenging issue and one we are taking extremely seriously. Contractors like us clearly have a role to play in managing this risk, but we can't solve this problem alone. If we are to achieve the aim of fully eliminating the risks associated with silica, it will take full buy-in and cooperation from regulators, unions, government and procurement agencies and contractors, so we can continue to progress towards the safest possible working environments. Thank you again for the opportunity to address this committee, and I'm happy to answer whatever questions you have.
Thank you very much for that opening statement, Mr. Smith. So we'll now go to questions. We've got a little bit under 25 minutes, so we'll share them around as evenly as we possibly can. So perhaps I'll start with the Deputy Chair, if he would like to kick off. Honourable Chris Rath.
Thank you, and thank you for that opening statement. It's helpful having some of that information. Thank you for appearing today. The projects that you're currently working on, is that Sydney? I've got a list here. Maybe you just confirm that these are the ones. So Sydney Metro West, the Eastern Tunnelling, Western Harbour Tunnel Project, Stage 1, Sydney Metro City and Southwest Tunnel, and West Connect, or previously I assume West Connect's M4 East, or is that still ongoing?
The only project out of those projects you've just mentioned, there are the Eastern Tunnelling Project is the one that's currently under construction.
So that's the one you're currently doing at the moment. The others are either completed or not yet started.
Yes, M4 East is complete. Roselle Interchange, which I don't think you mentioned, but that one is complete. Western Harbour Tunnel has just been completed.
And thank you. And the I don't know if you've had a chance to look at the submission from the Australian Workers Union. They've said that they've singled out John Holland for the highest level, this is a quote from them, highest level of respirable crystalline silica RSC exposure on those projects. Is there some, what information can you give us in response to that claim, in particular with these projects previous or that you're currently working on? Are there concerns in the operational maintenance of these projects that there might be ongoing respirable crystalline silica risk?
Well, we take all exceedances, as I mentioned in my opening remarks, we take all exceedances of the workplace exposure standard very seriously. We have had exceedances on our projects, both controlled and uncontrolled. Where there is an exceedance, those instances are investigated, and that information is shared with the people on the project, as well as reported to our regulators. We have a very robust safe system of work that controls silica in the air, in the atmosphere. And that safe system of work consists of our policies and procedures as well as our plans, and which includes the regular monitoring of silica on our projects. From time to time we do get exceedances, and as I said earlier, they are investigated thoroughly. The reason that we do get exceedances from time to time is that, and this happens generally in the area of health and safety when we're talking about management of risks, hazards and risks, is that we do get controls that fail or are absent, resulting in those exposure standards being exceeded. And it could be, the control that failed could be a mechanical failure. And that raises the exceedance level, raises the level to above the exceedance levels. So we do, by virtue of the geology in Sydney, dust does occur in the tunnelling activities, but we make best endeavours to make sure that those exceedances are kept to a minimum.
Thank you. And with these exceedances, or just generally, I suppose, in terms of dealing with the regulator, I think you said your regulator is Comcare.
Yes.
Could you walk through with us why is it Comcare and not Safe Work New South Wales? I assume you might have some contractors or subcontractors that you use that would be covered by Safe Work New South Wales, but your company's regulated by Comcare. What's the interaction there between Comcare essentially being a federal regulator and then Safe Work being state? How does that work in practice at one of these sites? It seems a bit confusing to us.
Yes, it is. It's a jurisdictional distinction.
Yeah.
We are the only construction company that is self-insured under the Commonwealth Act, which means that we're responsible for all our own insurance arrangements for workers' compensation and so forth. And with that comes the different regulatory oversight that is done at the Commonwealth level. So what that means is that any John Holland site where John Holland is the principal contractor comes under the jurisdiction of the Commonwealth. The Commonwealth regulations cover John Holland and John Holland direct employees. The subcontract workforce, which is made up of our subcontractors, are covered by the New South Wales Workplace Health and Safety Act. So we actually have two jurisdictions running concurrently on our projects. So that means to give you a practical example of what that means is that if we have an incident on site, we notify the regulators, we notify Comcare, and our subcontractors notify their regulator, which is Safe Work New South Wales. So at any given time when we have an incident on one of our sites, we can expect regulatory oversight from both the regulators.
Is it confusing, that sort of level of duplication? Like, you've got two different regulators you need to work with. It's not harmonised in some way. Are there practical problems with having a state regulator and a federal regulator, and contractors dealing with one and then you dealing with another, or does it work fairly well in practice?
Well, John Holland's been under the Comcare scheme for in excess of 20 years, so the company is quite conversant with how that dynamic works on a construction site. We make sure that in relation to the obligations of the contractors, in relation to their reporting obligations and notification obligations to Safe Work New South Wales, we make sure that those notifications occur. So we would make sure in our contact and interactions with the subcontractors that they have made that notification within the specified timeframes for notifiable incidents, etc. It's in construction, it's not uncommon to, particularly in joint venture arrangements where we might be in a relationship with another contractor delivering a project, we're quite conversant with managing and interacting with multiple stakeholders. What it means, again, in a practical sense from a regulatory point of view, is that we get a lot of oversight. We have both state-based regulators and national regulator overseeing our projects, which I think from a governance point of view provides an extra level of assurance that we're getting adequate oversight from the regulators.
And final one from me, Chair, if that's okay. Then
Yes,
I'll
please,
hand over.
please proceed.
You mentioned in your opening statement, but the data that you're collecting on silica exposure, is there information or data that you have that you're not giving to Comcare or Safe Work or iCare, for instance, that I assume you're probably not obligated to give it. Like you would have more data available than the data that you would give to the regulators. Is there such data that like additional data that you could be sharing with the regulators that you're not?
I think what's happened, my observation over time is that the regulators have really stepped up their level of oversight, particularly in the last 12 months. So we're seeing more regulatory activity from both regulators at state and federal level on our projects. And with that comes a requirement for more information. So it's only in the last, I'd say, less than a year that the regulators have asked for both uncontrolled and controlled exceedances. And they're working through, and we're working very closely, particularly with our government, the Comcare regulator, about their responses to controlled exceedances. So we do, to go back to the original question, we do provide a lot of information to them through their reporting portals, both regulators. We provide them with a lot of personal information as well about the individual, the name, their names and date of birth and that sort of thing, which is fairly straightforward when you notify of incidents to the Commonwealth and to the state regulators anyway. But we are well set up to provide whatever information the regulators require now and into the future.
Thank you.
Just before I pass it over, just if I could just jump in, you said, I understand you correctly, up to about 12 months or so ago, as I understand your answer, you were providing responses with respect to uncontrolled incidents, but now there has been the provision from about 12 months ago to both uncontrolled but also controlled exceedances. Is that what your evidence is?
Well, in my recollection is that we've provided both exceedances, both uncontrolled and controlled, for a period of time.
Right.
What seems to be happening at the moment is the regulator is interested in both.
Both, right.
Yeah, whereas before their focus was really on uncontrolled exceedances. Now they're paying more attention to controlled, but the conditions, I think, that give rise to those controlled exceedances are of more interest now than they have been historically.
But John Holland, before I pass it over, has collected data on both of those historically. That's your evidence? Yes. I might pass to Honourable Mark Banasiak.
Oh, thank you, Chair. Just in terms of, you mentioned about reporting requirements that you impose on or you make sure your subcontractors are doing their own reporting. What other measures do you put in place with your subcontractors to make sure that they are actually adhering to work health and safety, particularly around Crystal and Zilliger?
Well, one of the things that to give that question a bit of a broader explanation, if you like, we see the positive reporting of incidents as a very strong cultural marker of a positive safety culture. So we create an environment where people are encouraged to report incidents, and we encourage the report, we encourage information to go through the organisation very quickly, whether it's good news or bad news, and we see that as a real hallmark of a safety culture, and been working on promoting that over a long period of time. So that's the first thing. The second thing is that we would, we engage our subcontractors based on certain qualification criteria, and one of them is their safety performance and their culture of safety. So we make sure that we bring subcontractors onto our site that are aligned with our culture of health and safety.
Okay, so just picking up on that, Mr. Smith, how often in your tunnelling projects have you suspended, fined or removed a subcontractor due to their failure to adhere to this culture of safety?
That's not an uncommon event. I mean, if we're talking more broadly about how
I'm
we
happy
do...
for you to take it on notice in terms of an exact number. That's what I'm after.
Okay. Well, I can take that on notice, yes.
Yeah.
But in terms of the approach that we take, when we have an incident and it's thoroughly investigated, we look at the behavioural aspects of the incident, and we have a process which we call just and fair culture, where we apply awaiting to whether the incident, the actions of the individual was willful misconduct or whether it was a slip or mistake or an error. And on that basis, we make a decision. And generally, if it's willful misconduct, those subcontractors are removed from site and they don't return. But if you're talking about the quantum, I can certainly take that
would be
on
good.
notice.
I think we've all seen some of the documents that have come through on the SO 52, and not necessarily targeting you specifically, but there seems to be a long list of what I would put down as schoolboy errors and repeated breaches of basic stuff like wearing PPE that seem to just to continue on, and there doesn't seem to be an escalation of consequences. That doesn't necessarily point to a culture of good practice in terms of work health and safety, if those basic stuff are allowed to continue. If I am allowed to
please
just one
continue,
more, does your company have any policies around the use of unregistered vehicles or vehicles that wouldn't be considered able to be registerable on road to be used in these tunnelling projects? That's another thing that has come through in the documents, that there's been a bit of cavalier attitude to some unroadworthy vehicles being used in these tunnels.
Yes, I've read that submission. To get a vehicle onto a John Holland project in the condition that was described in that submission would be almost impossible. We have very strong systems of work around the procurement of vehicles for our sites and the checks that need to be undertaken before the vehicles are delivered on site or
Does
as
that
they're
include
delivered on site.
subcontractors coming on?
Same with subcontractors, yeah. So once they're underground, if we're talking about the tunnelling environment, and let me be clear, the tunnelling environment is a very harsh environment on vehicles, but they need to be maintained and fit for purpose whilst they're in operation underground. If any vehicle, and I can't think of a circumstance where we would find a vehicle with a rag in the petrol tank, which I think is the example you're referring to. I couldn't think of a circumstance where we would see a vehicle like that in that condition on a John Holland project or a joint venture. But the checks and balances that we have in place on a daily basis, where pre-starts and inspections are done on all the vehicles before they're mobilised to their work location, and then the monthly checks would make sure that those things don't occur.
Okay. Thanks, Chair.
Okay. I just want to ask, if we've got someone joining us today remotely, the Honourable Steve Lawrence, did you have any question that you'd like to perhaps lead off with in particular?
Yeah, I do, Chair. Thank you. Mr. Smith, could you just explain to us why your organisation didn't agree or oppose the release of the silica exposure data under FOI or parliamentary return orders?
Thank you. Well, look, as I said in my opening remarks, that was a decision that we took at the time. And with the benefit of hindsight, we wouldn't make that same decision today.
Thanks, but I'm just interested in the reasons for it as opposed to what occurred.
Well, the main objection that we had, and this was an application that came from a third party under the Freedom of Information Act for medical records, and in my experience, it's not uncommon for organisations to object under certain criteria for information under the Freedom of Information Act. The information that was being sought was information that contained personal information and personal medical records, not just exceedances and so forth. It actually had personal medical history and medical records of individuals. So we were concerned about releasing that to a third party. It wasn't until we were made aware of the third party was making that application and that information was going to be used for the purposes of academic research. When we did finally agree to releasing in information, we agreed on the basis that the records were redacted to protect the personal information of those people that were in those records. And again, if the decision that we made at the time, we made that decision at the time on reflection. What we should have done and what we would do now is to ask for those records to be redacted early and released.
Yeah, I was going to say, because are you saying that the only reason for the lack of cooperation was the privacy of the workers, or was there other reasons?
No, that was the primary reason that the organisation responded in the way that it did. There was, I'm aware that there was a letter drafted by the project on the Rozelle Interchange project, setting out the reasons why that objection was made, and in that letter, it says that the objection was based on reputational impacts to the organisations in question and the ability to win future work. Now, the fact of the matter is that those reasons that are set out in that letter were done so based on the criteria that could be selected for objecting to that request for under the Freedom of Information Act. But the primary reason was that we were concerned about the privacy of those records.
So there's obviously a difference between something being a primary reason and something being the only reason. So are you saying that the protection of reputation of the company was a reason, but not the only reason? No. Let me be clear.
The reason that we objected was the privacy issue. The reason that the criteria that's set out in that letter that went in a formal sense as an objection to that Freedom of Information Act request was because of the limitation in the criteria that can be selected for that objection. But no, our only objection was the privacy of that information.
And the only consideration that you took into account in making that opposition was the privacy of the workers. You had no regard to any other consideration. Is that the evidence?
Yes, that's correct. Okay. And I would add to that, if I can, that we have very high levels of transparency around sharing data, information within the organisation with people that need to know that information, obviously de-identified, and we also share that information readily with our regulators, and our unions are aware of that information as well, because we have health and safety reps on our projects that are there to represent their members.
Sure, okay. Moving to more substantive matters, John Holland was legally required to control CS exposure to below the 0.05 threshold as far back as 2020. Can you explain why workers continued to be exposed to levels many times above this, sometimes for months?
I can't comment on the duration that you've just specified. But what I can say more broadly about exposure is that, and I mentioned this in my opening remarks, is from time to time the exposure standard is exceeded, and that is generally in response to a failure of a control or an absence of a control. And a practical example of that is, as I mentioned earlier, our last line of defence for our workers is the PPE, the VersaFlow masks. But if people don't put the mask down, it negates the protective factors of that PPE. So that in itself causes an exceedance to the individual, an exposure to the individual, which is unacceptable. It could be a failure of a mechanical control, like a mister that's blocked, that causes the air quality, the standard, the workplace exposure standard for silica to be exceeded. So there's many reasons as to why a control can fail. They're not immune to failure, particularly mechanical controls.
But are you saying the company was unaware of repeated exposures and that's why it continued? Or are you saying something else?
No. If there is an exposure, when an exposure occurs, we are made aware of it because it's picked up through the workplace monitoring and the surveillance program. So either static or personal monitors would detect that, and generally the exposure is over a shorter duration. But we need to be made aware. Our monitoring systems need to pick up those exceedances as they occur in order for us to address them.
Thank you.
So if your own data
Stephen, sorry to cut you off.
Sorry, Chair.
No need to apologise. We're nearly at time, but with your concurrence, Mr. Smith, could you another 5 minutes just to sort of deal with a couple other questions?
Yes, absolutely.
Yeah. So, Stephen, could I just pass over to a couple other members just to let them have a chance?
Sure.
So, sorry to cut you off.
Sure, thanks, Chair.
To start with Ms. Abigail Boyd.
Thank
and
you
then
very
Mr.
much.
Honourable Rod Roberts.
Thank you very much, Chair. Thank you, Mr. Smith, for being here to provide evidence. I just wanted to Just two main issues. So this release of data, your evidence here today is that that was not released to begin with because of personal information concerns. Is it your evidence that your legal department is previously unaware of the ability to redact personal information? It's incredibly standard in GIPAs, in SO52s, for personal information to be redacted. Is your evidence that when Transport asked if that information could be released, your legal department just said no, rather than, well, yes, but only if that personal information is redacted?
I would need to take that question on notice.
If you could, I
Yes.
think that would be good. You also said that there is a very high level of transparency within your organisation when it comes to this information. Looking, I guess, externally from the organisation, the Western Harbour Tunnel site in particular has been a sort of a vexed location between, particularly before 2020, for that information that was being sought by the unions. My understanding is that that information not being provided to the unions actually ended up in court in a way, because there was a, I understand that John Holland was sued by the union for refusing to allow the unions to bring on sort of dust detecting equipment.
Yes.
That evidences quite a long struggle of trying to get information out of your company. What happened with that case? Where are we up to?
That was quite a protracted process, and the project and ultimately the company and joint venture partner in that situation agreed that and this was over the right of entry provisions, and we disputed the union's right of entry reasons at the time, and we stood by that decision because we were concerned with the methods that were going to be used for the sampling of air quality on that project for silica. The particular device that that the unions wanted to use, we had no confidence in its ability to monitor for silica. It was a dust tracking device, or it took air quality samples for dust and not for silica. It wasn't able to detect silica at the levels that was required to be, so we had no confidence in those results. So what it came down to was we challenged the union's right of entry to come in to do that monitoring, because the unions have a right of entry to come onto projects based on certain criteria, and it's generally that they have concerns from a imminent health and safety
They took you to
point.
court for it.
Yes.
What happened to that case?
Well, that's now resolved.
How was it resolved?
We agreed to come up with a protocol for the use of that dust tracker, and we would allow them to come on site to use it under certain conditions. Now, the union, the AWU union, this is what I'm referring to, were involved in the drafting of that protocol.
Did you get any financial sort of penalty for that? Was there any financial cost to the company from that case?
Only the indirect costs associated with people's time, but no, there wasn't any penalty.
And just a final question, if I can, just obviously after these revelations of particularly CPB workers being diagnosed with silicosis, and it now looking like there's quite a high risk level for tunnel workers when it comes to silicosis, what has your company done to check at the levels of disease within your workers?
Well, we already have a very robust approach to medical surveillance on our sites. We do, so to give you an example, we would ensure that as people come onto our projects and they're working underground, that they undertake a baseline lung assessment. So we would collect the history of their work history, basically, what other projects they've been on, which is useful from the point of view of tracking people in the industry. Tunnel workers, it's a very small cohort in Australia, and generally people move around between employers and projects. And then once they're on the project and they've been through the training and induction process, we would have medical surveillance for them on a regular basis, which would include, we've just moved most recently to best practice diagnostics, which is the high resolution CAT scans for all of our employees, as a more sophisticated way for diagnosis. So we would just incorporate the monitoring of those individuals through our own on-site surveillance programs.
And is that testing information then available in some way for people to see? Is it given to the regulator? Is there any transparency over that testing data?
The personal information and the medical records are generally not provided to the regulator. They're provided to the individual. And obviously we retain them. We have the obligation under the legislation to retain the medical records.
Thank you.
Thank you. The Honourable Rod Roberts.
Thank you, Chair. Thanks, Mr. Smith, for your attendance today. I have just two questions there as a result of your evidence that you've given today. In your opening address, when you were talking about air quality monitoring, you used the terminology, we de-identify results. Could you explain to me what you mean by that?
Sure. Yes, thank you. What that actually means is that we don't identify the individuals that have been
So
exposed.
you're talking about individuals, not sites, when you
Yes.
say you de-identify the results.
Yeah, so we don't. It doesn't go to the extent of de-identifying the site. We talk about the work location, the level of exceedances over what period of time. We just don't name the individuals involved.
That's fine. That clears that up. And the other part was in answer to a question from my friend, the Honourable Chris Rath. We're talking about exceedances, and you used again the words that the controls may be absent.
Yes.
What do you mean by that?
So a good example of that would be going back to the personal protective equipment and the VersaFlow, which is really an encapsulated mask. It's completely ineffective if the face shield isn't down. So you've got a level of control there that's just absent.
Is there any other controls that are absent that you're referring to, or is that the only example
No,
you've got?
Generally we find when we investigate any safety incident, there's generally a failure of a control or the absence of a control. So if a control hasn't been selected and then implemented, then we would use that terminology. So if people weren't wearing, again, a low-level control, if people aren't wearing their safety goggles or their safety glasses and it results in an eye injury, then we would say that's an absence of a control, not a failure of a control.
What other controls are absent though? What are you referring to? Because you said in terms of exceedances, obviously eye injuries aren't exceedances of the silica level. You said that would be perhaps because controls were absent. Well, what is absent and why are they absent?
Well, generally, in the context of this particular topic, it's usually a failure of a control rather than an absence of a control, because we have lots of checks and balances in place to ensure the controls are in place.
Well, Mr. Smith, though, your own evidence were, and these are your own words, that the controls were absent. You didn't say, you may have said there was a failure of controls, but you also said controls were absent. I want to know how on a work site that's regulated and controlled that these control methods are actually absent from the workplace.
Yeah, in the context of my opening remarks, that was that just explains what is attributed to an exceedance. It's either an absence of a control or a failure of a control. So there's generally two categories of control failure or absence of control. So I use that as a category, if you like. In the context of the incidents that we have in relation to exceedances, it is generally a failure of a control rather than an absence of a control, because of the planning processes and the checks and balances that go into our systems of work. Those controls are there. It's when they fail, and they could fail because of, so if we talk about some of the mechanical controls, as an example, I'm not suggesting this has happened in the cases on our projects, but a ventilation system could fail, a scrubber could fail, a scrubber could get blocked, and that affects air quality, and therefore the exceedance occurs. Now that could happen for a number of reasons. It could be maintenance issues, it could be a range of things, but that is an example of where a control would fail as distinct from an absence of a control.
Right. So I note the time, Chair. Just a follow-up to that, though. On notice, could you provide to the committee then a correlation of where you've had exceedances and whether that was a result of a lack of control or a failure of control. Can you identify those and provide them to us?
Yes, I think so. I mean, I could do that, but I would need, as my reference point, to have an investigation report to refer to, because that's where the detail would be in the investigation findings, as whether it's a failure or an absence of a control.
But you have
I can
access to
take
those
that.
reports, yeah?
I can take that on notice, and I can have a look at those reports where there has been an investigation, and take that on notice.
Right, thank you, Chair.
Thank you very much, and thanks for agreeing to stay on a bit longer. So thank you, Mr. Smith, very much. There's some questions on notice that you've agreed to take, and we're grateful for that. And I expect there might be, following reviewing the the Hansard, members may have some supplementary questions. So our secretary will liaise with you in regards to both of those matters. So thank you very much.
Thank you, and thank you for your time.
Thank you, gentlemen, for both coming along this morning. We'll get through the formalities first, which is I'll ask you both, starting from my left, to state your name, your position title, and then take an oath or an affirmation, whichever you prefer, the words of which should be before you. So we'll start. Thank you.
Okay, thank you, Chair. My name is Glyn Edwards. I am the General Manager for CPB Tunnelling and Major Projects.
Thank you.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Edwards. Mr. Sylvester.
Thank you, Chair. My name is Graham Sylvester. I'm the General Manager of Safety, Health, Environment, Quality, Sustainability and Rail Safety for CPB Contractors.
Thank you.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Mr. Sylvester. We'll now follow with an opportunity to make an opening statement. I gather there might be just one opening statement.
Just one, Chair.
Yep. So over to you, Mr. Sylvester. Thank you.
Thank you, Chair. Thank you, members. Good morning, honourable members. I am Graham Sylvester, the General Manager of Safety, Health, Environment, Quality, Sustainability and Rail Safety at CPB Contractors. I'm joined by Glyn Edwards, General Manager of Tunnelling for CPB Contractors. We are here to respond to any questions that you have related to the New South Wales Parliamentary inquiry into the 2024 review of the dust diseases scheme. And we thank you for the invitation to attend and the opportunity to address the committee with a short opening statement. CPB Contractors has been proudly building our nation's transformational infrastructure for more than 90 years. The health and safety and well-being of our people is a priority, and this includes protecting our people from the potential exposure to respirable crystalline silica, also known as RCS. CPB work with independent health and hygiene experts to address the potential exposure by eliminating or minimising the risk through the application of known or new engineering controls, updating our training programs and personal protective equipment, including respiratory protective equipment, and by implementing worker health monitoring processes supported by leading occupational physicians and respiratory physicians. Specific to RCS, our commitment to health and safety is demonstrated through our leadership via several initiatives. We were the first contractor to adopt the use of powered air purifying respirators, also called PAPR, for all roadheader operators in 2022. This initiative was then expanded at scale to all underground workers in proximity of excavation activities. We were the first contractor to implement low-dose HRCT scans based on risk and employment history at the recommendation of our occupational physicians as part of our health monitoring program. We employ a full-time occupational hygienist on every tunnelling project. We also invest in academic education for our people, providing opportunity to complete internationally recognised certificates of occupational hygiene. We have also worked with our supplier Orcott to redesign our crib rooms to ensure that they are pressurised, setting a new standard in the industry. We engage and rely on independent certified occupational hygiene experts to conduct personal air monitoring across our projects, with these results shared with our workers and exceedances notified to the regulator as required. We financially support the Prince Charles Hospital, its scientists and the Tradie Health Institute program by investing in its research into the early detection and treatment of disease associated with RCS. We recognise the critical role that we have in protecting our workers, and we value the collaborative relationships that we have across our joint venture and delivery partners, supply chain, clients and safe work. We have a genuine desire to work with all relevant stakeholders to productively use our knowledge and data and further develop industry initiatives. However, this issue is bigger than any one contractor or project. For this reason, we would like to commend the New South Wales Government for establishing the Tunnelling Dust Safety Task Force, and we embrace the call to maintain and reinforce a set of industry-wide minimum standards to ensure worker health and safety in all tunnelling environments. Thank you again for the opportunity to speak, and I now welcome any questions.
Thank you, Mr. Sylvester. So we'll share questions around. There's representatives here from crossbench, opposition and government, and I'll invite the Deputy Chair, Noel Cushrat, to kick off.
Thank you. Thank you for the opening statement and for appearing today. I was wondering if you could expand a bit more on what your standard air quality monitoring procedures are, and also how is an extremely high level of RCS reported to the regulator?
Sure, and thank you for the question. We have quite a detailed risk process when dealing with occupational hygiene issues. It's underpinned and anchored by the engagement with an independent certified occupational hygienist. As I said, we do recruit occupational hygienists on each of our tunnelling projects. So we ask them at the early stages of a project to undertake what we call a level 1 assessment of the hygiene exposures. We then ask for a walkthrough, which is our level 2 assessment, and that's conducted again by our on-staff occupational hygienist. At a point in time, shortly after the start of the project, we bring our independent certified occupational hygienist in. They review the level 1 assessment, they review the level 2 assessment, and then they undertake a level 3 assessment where they create a respiratory protection program and an air monitoring program that's then implemented across the project throughout the life of the project, with air monitoring commencing within no later than 1 month of work commencing on the project. And
if there is an extremely high level of silica exposure, is that reported to, I assume you deal with safe work rather than
Yes, we do.
Comcare. is that reported to Safe Work in real time, or how soon after the incident would that be reported to Safe Work?
Sure. With the hygiene assessments that are undertaken, there's normally a lag of time between when the independent certified occupational hygienist undertakes their work, so their samples, when they're then sent to a NATA laboratory and we get the records back, and there's generally a lag of somewhere between 14 to 21 and sometimes 28 days.
And that's because you need to do that work with the laboratory and
Yeah,
so forth. So you couldn't give it to Safe Work immediately, even if you wanted to. Like you need to.
No.
Yeah. Okay. And just interested in whether you track worker health post-employment or post-employment on a specific project relating to any data that you have on silica exposure.
So we make all attempts that we can to do that. We're not always successful. There is a level of worker emotion, obviously, around being exposed to occupational hygiene risk, and particularly RCS, and we've experienced that where workers don't want to know, but we make every attempt that we can. Any worker who is diagnosed with a silica-related condition, we ensure that they are put on a health management plan, and that health management plan is shared with their general practitioner.
Thank you.
Thank you.
Chair.
Before I pass it over to one of the Crossroads members, just returning to that point about workers not wanting to know, could you please elucidate on that and perhaps give an example of an experience where this has happened? Without necessarily naming an individual, but just so we can conceptualise what that means.
Yeah, look, I think it's human nature, and I know I've experienced it myself, where there's some initial diagnostic done on the self, for example, and then that leads to additional diagnoses where it can come up with a diagnosis that you don't want to hear. You know, and so there's a real stigma around silicosis, and I can understand why. And I genuinely feel for anyone who gets a diagnosis that they may perceive is going to affect their future. You know, we've had people who've been diagnosed with silica and who just don't want to talk to us anymore, and I understand that. You know, it can be, if not identified early, and that's why we've gone down the pathway of using low-dose HRCT, because we want to make sure that we look after our workers the best possible way, get the best possible diagnostics involved, so that, you know, if it's caught early enough, then they will live a long, productive life, and they, you know, it won't be the cause of any end of life if we get it early enough. And you know, and if there was one thing that I would really want to see this committee resolve, is that we have to use low-dose HRCT. It has to be mandated in this circumstance. I just can't see any other way around it. X-ray and spirometry is 150-year-old technology. You know, by the time X-ray and spirometry identifies a case of silicosis, I can understand why people would be emotional. I can, and I really feel for them. We have to do low-dose HRCT.
Thank you for the evidence. Now, just so people know, I've got the Honourable Mark Bedazek, then the Honourable Abigail Boyd, the Honourable Rod Roberts, trying to share this around and then back to government. So if that order is agreeable, so the Honourable Mark Manassian.
Thanks, Chair. Just two quick questions. First one following up from the Honourable Chris Rath. You talked about a lag of sort of 14 to 21 days. On receiving the results, how quickly do you pass on that data to SafeWork? Is that immediate?
Look, we have had one issue where we didn't, and that was an error on our part. And as soon as that was identified, we notified, that was wrong on our part, and we accept responsibility for that.
Yep.
But we notify as soon as we possibly can.
Okay.
Now, there might be a lag of a day or so, but there's no more than that.
Yep, sure. And just secondly, it's a similar question I put to John Holland. Your website talks about a collaborative approach to procurement with your subcontractors. In your tunnelling projects, how many times have you fined, suspended or tore up contracts with your subcontractors for failure to adhere to work health and safety with regards to RCS? And have you placed any of those subcontractors on a to not to be procured again list?
Yeah.
Happy for you to take that on notice.
Yeah,
I'm
no,
after a specific figure.
Certainly, member, if you like exact numbers, we will take that on notice. But from a moral perspective, and I always come from a moral perspective. I think legislation's fine and we need it, yes, but in my view, we come from a far higher standard, and that's morally we want to make sure that we do all that we possibly can. From a moral perspective, where there are people or companies who, for whatever reason, and we would need to understand what that reason was, are not complying with our system and process. If that reason is, don't care, it's all talk, then we will deal with that contractor or that individual, and we will exclude them from the workplace. And I personally have put, we have a system and process to engage our contractors, and I've personally put bans on contractors being engaged because of that.
Okay. Thank you.
We go, Boyd.
Thank you. Thank you for coming. I should say that to begin with, because I think it's really important that we do hear from people like
I actually
yourselves.
appreciate the opportunity.
Yeah, thank you. It's obviously really shocking to hear about cases of tunnelling workers contracting silicosis. And it's one of those things that, a little bit like with manufactured stone, it sort of creeps up and then it becomes very well known. And now there's quite a lot of attention on it, which is a good thing.
Yes, it is.
Given the recent reports about the numbers of tunnelling contractors who have already identified as having silicosis and who we suspect are likely to get it in the coming decades, what is your company doing differently to try and add, extra protections? Is there something extra that you're now doing as that information is coming to light?
Can I thanks for the question, member. I'm going to deal with it in two ways, if you don't mind. We notified 13 cases of silicosis on M6. That was because we've implemented low-dose HRCT. So we're getting it far earlier. So it's the advice that we've been given by our occupational physicians and respiratory physicians tell us that if we find it using low-dose HRCT, then the worker should, if they follow the advice being given, live a normal, healthy life. That's a massive difference to X-ray and spirometry detection. Okay, so that's why the 13 cases were identified on M6. It wasn't because of the work on M6. When you look at the career history of those workers, they worked with different contractors in tunnelling around Sydney. They worked in mines in New South Wales. It's a career exposure. And again, this is the advice that I've been given from our occupational physicians, is that the silicosis the workers have been diagnosed with, and I'm not understating the diagnosis, I'm not, but what they have been diagnosed with is called simple silicosis. And again, what we've been advised is that simple silicosis occurs after low to medium exposure over decades.
Mm-hmm.
It's not something that they would have been able to acquire in the short period of time between their pre-employment medical and then their health surveillance medical. That's called acute silicosis.
Can I just stop you there? Sorry,
Sure.
just because time is limited. It's obvious that workers are going to work on different sites. Sometimes when we have those sorts of scenarios, you end up with a situation where no one takes responsibility because you can look and say, well, obviously this worker worked somewhere else. So, but from a worker's perspective, what they're looking for is for their current employer to do everything they possibly can to stop adding to that exposure, I guess. So just bring you back to my question, which was, what are you doing differently now?
Sorry.
To sort of up the protections for workers.
So what we are doing, there are two anchors to our system. One is obviously our independent certified occupational hygienist. The other one is a ventilation engineer. We want we want, and that's something else I'd love to see the committee arrive at, is something around ventilation, because it is one of the primary controls to manage exposure. So the ventilation engineer comes in, he designs the ventilation system for the tunnel. Now, that includes air movement, it includes direction of movement, it includes things called scrubbers, and my colleague Mr Edwards will tell you more about a scrubber than I could ever tell you about. But it's basically a vacuum cleaner that cleans the air in the tunnel. So we have the scrubbers there, we have them as close to the face as we possibly can, depending upon the excavation technique that's being used. And again, my colleague will be able to provide more information on reasons why and which techniques we use. We have the scrubber up there at the face. As I said, we have we have high pressure nozzle spray. We have wetting agents to actually minimise the level of dust. With any equipment or machinery that goes down into the tunnels, we have a strict regime of ensuring that everything is sealed, that those seals are regularly checked and tagged out if they're not in place. We have air conditioning systems in with filters that are regularly maintained. We have workers in VersaFlow masks.
Is there anything new, I guess? Is there anything...
Look, we are...
Just two things as specifically. So from an engineering perspective, in engineering control, we have enlarged the fans that we would typically have used on previous projects so that we can get more air into the tunnel, which basically gives you fresh air, which helps to blow it out. We are restricted in the tunnels by an air velocity, which is basically 0.5 metres per second. We can go higher. Now, what we need consistency here is one standard says it can be 0.3 metres per second and one standard says it can be 0.5 metres per second. We typically go to we always go to the 0.5 metres per second. The issue is if you get too much air blowing through, you get the wind chill factor. And I'm serious, it's a hot, sweaty environment, but when you've got too much air blowing in, that is one thing we have done on our project, is enlarging the fan so you can get the airflow.
Mm-hmm.
And I think the second thing that we have done, which is new on our projects, as Graham has previously alluded to, is we have introduced the PAPR, the VersaFlow masks, which is basically a filter that you stick above your bum, basically. It's got a tube that comes into a helmet. It's a picture of a typical helmet that you would wear on site. It's slightly more robust. It's got a face mask like a welding mask. It's got a little bib that comes under your chin. It blows fresh air in, again, not at rapid rates, but it's I personally have worn them. They're quite a comfortable thing to wear. Certainly far more comfortable than wearing your typical dust mask, which is, they're just not pleasant. But we have moved to that. So there's, I guess, two examples of increasing fan sizes and also the VersaFlows, which gives you a factor of, from 10 on a typical mask to 50 times the exposure on a PAPR.
Thank you.
The Honourable Rod Roberts. if it's-
Yeah, thanks, Chair. Just a couple of questions again, because I note we're running out of time.
No, that's
Thank
okay.
you, gentlemen,
Take
for
your time.
attending. Mr. Sylvester, probably best addressed by you, but could be Mr. Edwards. When did your company, CPB, actually mandate the use of PPE in tunnelling projects?
Oh, God. The specific date I'll have to
Take
take it on notice. But
yeah, that's fine.
look, I started in the business 26th of July 2013.
Yeah.
We were using PPE then. I started out as a carpenter in construction in 1976. I can remember us wearing PPE in 1976.
That's in a tunnelling project.
No, that was...
Well, that's what I'm referring
Yeah,
to.
yeah,
Again,
okay.
I appreciate it, and I'm not being rude by cutting you off. It's just we're on the clock. So,
Sure.
Do you want me to?
yeah,
No,
sure.
please.
So
yes.
I have worked for a CIMIC, I'll call them CIMIC company, CPB, basically, it used to be the Leighton's companies. I have worked with one of those companies for the past 22 years, and my recollection is certainly in tunnelling, when it comes to the likes of dust masks, when it comes to the engineering controls like the scrubbers we're talking about, we use a different scrubber now. So to the best of my knowledge, since 2003 is when I started working with a company and in a tunnel environment, and we had dust masks, we had the scrubbers, we had the glasses, we had helmets, we even went to the long sleeves for UV protection. Not that you have it under tunnel, but we all underground. But we also introduced that because underground it's a hot, sweaty environment. Basically, that's why we introduced. So to answer your question, in tunnels, to the best of my knowledge, 2003 is when I
Okay,
first.
so you're wearing it, and then when did you, as a company, start enforcing compliance then on the wearing of those masks?
To the best of my knowledge, back in 2003.
Okay,
I can't comment previously to that for tunnel works.
right. So going back to the dust mask that we're talking about, not the VersaFlow, right? There is a question about VersaFlow, but the dust masks themselves, when did you as a company realise that they were in adequate protection? We know they're at the bottom level of the hierarchy of safety. When did you realise that they were they're fairly useless? Because let's agree that they're not protective completely because of sweat. We know you've got to remove the mask to communicate with others. So when did you decide that they were probably an inappropriate form of PPE?
I think, to be fair, member, this has been an evolution and it's been a journey that we've been on for many years. We are always on the outlook for new technologies, better things, easier way to do things. And as you point out, even PAPR has its limitations, and we're working with suppliers now to come up with a communication method so that you can talk to someone next to you, because at the moment with the PAPR it's difficult to hear the person standing beside you. So certainly from at least 2022 we've had a mandate for PAPR, particularly for road headers, and that was expanded later to all people involved in excavation activities. But we've used PAPR well before 2022 as well.
But you mandated it from 2022?
Yes, we did.
Okay, that'll do me, Chair.
Thank you. Can I just deal with what's been activities by the Parliament, by the Legislative Council, and also others in terms of seeking information from CPB contractors in regards to exposure of workers on your projects, which has been over a period of time. And there's been opposition to that release of information, and that obviously was a conscientious decision taken by the company to do that. I'm wondering if you could explain to the committee, excuse me, why that opposition was put in place in the first place to resist the provision of the information that was being sought.
Sure, and thank you for the question, Chair. I'm going to ask my colleague, Mr. Edwards, to respond to that, and I'll come at the end.
Thanks, Graham. I just want to sort of, before I go into that exact detail,
Please.
I want to just address what we perceive as a misunderstanding that because CPB objected to the release of certain GIPA applications, this by implication means that we're not necessarily sharing that information with certain parties. Now, from our perspective, from a worker perspective, we share this information, be it dust monitoring information, with our workers via pre-start meetings, toolbox talks, and also publishing the information on notice boards. So that is a routine, regular activities that we perform. From a union perspective, we facilitate right of entry notices from the unions for a number of different reasons. It might just be to talk to address the troops, address the workforce. It could be for certain work health and safety matters. But when it comes to, on occasion, we have been asked for the production of air monitoring data. Now, that information has been facilitated, and as far as to the best of my knowledge, the documentation has been provided to the unions. So to say that, there is an implication, there is a misconception, a misunderstanding that we are not providing information to certainly the workers and certainly the unions.
So, if I understand correctly, the evidence you're providing is that the information that has hitherto been sought through the FIA mechanism has been duly provided. That's been done. Is that your evidence?
So my story, there's more about each individual project. So from, we provided the information we thought confidentially in discussions with our clients and the regulator, we understood that they were looking to provide the information anyway, so we withdrew our objection to providing that information.
Okay. If we just move to another line of questioning in regards to the 0.05 mg per cubic metre exposure limit. So as you'd be aware, you've been legally required to control RSC exposure to that limit of below 0.05 mg per cubic metre as far back as 2020. Can you explain why workers have been, on occasion, continue to be exposed to levels many times above this, sometimes for extended period of times?
I'm not, thank you for the question, Chair. I'm not sure of the specific examples that you're referring to. Just because there's an exceedance that's been identified as part of air monitoring doesn't necessarily mean that a worker has been exposed to respirable crystalline silica because of the controls that would have been in place during that air monitoring and during construction activities. I think it's important to note that wherever there is an activity that involves fracturing rock, grinding rock, drilling into concrete, there's a risk of exposure to respirable crystalline silica. And obviously the more that activity occurs, the more potential there is for an exceedance of the WES for respirable crystalline silica. So I don't think it necessarily follows that just because an exceedance occurs that a worker is exposed. With the occupational hygiene monitoring undertaken by our independent certified hygienists, they take notes of what they see while they're undertaking that monitoring. When those results are known and they come back, and if there is an exceedance, then we conduct an investigation to understand what was in place in the time, was it working, and was a worker exposed. If we determine as a result of that investigation, that a worker was not exposed, then we will notify that exceedance as a controlled exceedance, because the controls were in place and the worker was not exposed to the risk.
And perhaps if I jump in, and thank you for your concurrence to go beyond 10 o'clock. We're delayed with the previous witness. My final question in regards to the real-time monitoring of dust inside tunnelling. Can you provide evidence to the committee, if you could, about the work that may be being done by the organisation to bring that into place, if it's not there already? And if it's not there already, what are the inhibitors, or what's really preventing that being done?
Sure.
As a piece of engineering, practical monitoring activity inside the tunnels.
Sure. So we are adopting and have adopted real-time dust monitoring in our tunnels. The issue with real-time dust monitoring is that it just monitors the dust level. It doesn't discern between respirable crystalline silica or other dusts. So we've got to do more work in that space, but we are down that pathway already.
But in terms of the material being bored through or tunnelled through, it would be correct to say that in terms of what that material is, it's almost guaranteed in terms of the geological structure in parts of the broader, Greater Sydney Monterey area to contain silicon dust. Would that be correct? Silicon dust?
Well,
I mean, it's not a case that you might find it here but not there if you're talking about generally the tunnelling work in the Sydney Greater Metropolitan Area.
Yeah, look, I think that's fair to say. I think, the geology of the rock in and around Sydney is mostly Hawkesbury sandstone, and therefore there is a risk. Yes, I agree.
Yeah, okay, thank you. Well, there might be some further questions arising from members having the opportunity to read the Hansard after today, and some follow-up questions in terms of you may have taken on notice or we'll be looking at. So our Secretariat will liaise with you in regards to that. But once again, thank you both for coming along today. Much appreciated.
Thank you. Thank you for the opportunity.
Yeah, thanks for
Thank you.
inviting us.
Thank you.
Thank you. We now have morning tea, which I've truncated by a significant amount of time by my poor sharing of delay.
Cranky.
And members are getting obviously uptight about that. No, only joking. So I'm wondering, it's nearly gone 20 past. Okay, we'll return after the morning tea break, and welcome back, everyone. And we'll move to our next witness, which is Mr. Cornelius. Is it pronounced Buitendag?
Buitendag.
No, thank you very much. I thought I'd nail it, but I almost nailed it. So thank you very much, and welcome for coming along. So we proceed, first of all, by a formality of inviting you to state your name, your position title, and then take an oath or an affirmation, whichever you prefer. You should have the words in front of you,
Yep.
and then an opportunity to make an opening statement. And then, if agreeable, we'll share then the questions around between the members of the committee, and there's members here from the opposition, the government and the crossbench. So are you okay with that way we proceed?
Yes, thank you, Chair.
Thank you. So name, title and oath or affirmation first. So thank you.
Good morning, honourable members. My name's Cornelius Buitendag. I'm the National HECQ Manager for GELA within the Australian area. I would like to do an oath this morning. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. So with that out of the way, would you like to proceed and make an opening statement?
Yes, please, Mr. Chair.
Please proceed.
Good morning, honourable members. I would like to thank you for this opportunity to appear before the Standing Committee in relation to the 2024 Dust Review Scheme. As I mentioned, I'm the National Corporate Health and Safety Manager for GELA. GELA is involved in infrastructure and tunnelling works, we typically operate as a minority partner or shareholder within joint venture partnerships with larger principal contractors, working within their stated safety management systems, which just assures us that there's a more precise, streamlined and clear way of managing one particular system on each and every project. Having said that, we fully accept our responsibility as a partner towards the health and safety and well-being of every single worker on each and every project that we are involved in. We are committed to maintaining a safe, healthy and workplaces and actively manage associated risks, which might include silica. We work closely with our partners and industry bodies, inclusive of regulators, to continually strengthen and protect our workers from risk or harm. We welcome the committee any questions and are here to support this inquiry in any way we can. Thank you.
Thank you very much, and once again, thank you for coming along today. It's much appreciated. So we'll start with the questioning, if that's okay. I'll share the questions around. So we'll start with the Deputy Chair, Honourable Chris Rath.
Thank you. Thank you for appearing today. I asked the last witness this question. I want to ask you as well. What are your standard procedures for air quality monitoring, and how is an extremely high level of RSC reported?
Thank you, Honourable Member. I would like to also refer to
If it's more convenient, you can pull it, sorry, just so it might be more, pull it forward so you don't have to leave, so yeah, that's easy.
Right.
Yeah, make it easy for you.
I would also like to refer to similar answers that was given by some of our partners within the previous two sessions. The basic principle stays the same, as mentioned, due to that being the principal process of those contractors that we are involved working in. The key areas that we do focus on is taking a risk-based approach, whereby we involve certified occupational hygienists to form part of a team that do or take sampling in accordance to relevant standards set out within Australian standards. That is taken or elevated through a 3-level basis of risk assessment. Level 1, which is a baseline risk assessment conducted even prior to starting of work. A level 2 risk assessment, which basically follows through with the appropriate and adequate people taking sampling on a project. And then a level 3 might be sampling taken on workers every monthly, as often as every month, whereby those data parameters are then sent to a laboratory and then we get feedback from the laboratory on that on a paper.
And similar time-frames to
The time frame, to my knowledge, is the same. Yes.
Yeah. And I'm not sure if you can answer this question, but how do you think that New South Wales compares, or Australia compares, to international jurisdictions on silicosis? I know that Geller's involved with projects all around the world. I was reading, was it a high-speed rail between Lyon and Turin that you're developing? What sort of are the policy settings in other jurisdictions? What do they do well, and what do we do well? If you can answer that question, I know you might not be involved as much with international, projects.
Yes, thank you. As far as I'm concerned, and as far as my knowledge goes, the process are quite similar, albeit very different regulatory or legal requirements. It is my understanding, and especially with the 2024 updated crystalline silica regulation, that within that regulation or standard, it's quite robust to what we've seen recently taken place within the Australian environment. But in general, the policies and processes are quite similar in terms of the risk-based approach and utilising a similar, line of, the hierarchy of control of implementing control measures.
Thank you.
We'll go to Abigail Boyd and pass it on then to some other members.
Thank you.
Abigail.
Thanks very much, Chair, and thank you for coming along today. I just wanted to ask, I think we've heard a lot about these, the higher order control measures, and then the obviously masks and things being sort of a last resort, or the last sort of line of defence. As technology has increased and our knowledge has improved, what has your company been doing differently to improve that sort of higher order control
Yes.
in tunnels?
Yes, certainly. Look, what I can speak to from my knowledge in the past couple of years is that even prior to the introduction of the updated regulation of September 2024, Geller and its associated partners, as far or as soon as or as early as around 2018, from my collection, have been working with Safe Work, have been working with experts in the field, have been working with clients to improve systems and processes to protect workers from silica dust. Out of those discussions and workshops, various items have come up that has been implemented, and I believe the previous members have also discussed that in a fair bit. A couple of examples, if you don't mind. So, of course, we've got the tunnel ventilation management system with scrubbers and all that, but things that stand out that has changed in the last couple of years is, of course, the utilisation of HEPA filters, sealed cabins within, machines, plant and equipment to allow those workers inside not to be exposed to any particular RCS dust. In addition to that, power tools, for example, have been fitted with vacuum machines and HEPA filters to extract the dust at the source of cutting or where rock has been broken. Various amount of vacuums are used. And in addition to that, I believe the RCS management programs have adopted a fair bit in the last few years to put in place more stringent action plans where there are exceedances.
And are your workers using these PAPR masks?
Yes, absolutely.
And is that a sort of a standard, or are they sort of depending on sort of which project or which worker?
Look, from what I can say, it's been a standard for at least a couple of years in the projects that we've been involved in with our partners. It's a very good system. It is a system that we do a lot of training on to the employees to ensure that they understand how to utilize them, maintenance programs, how to keep it clean. We even set up a system on each site where there's a whole team for storage and maintaining and cleaning them, keeping those equipment to a level that it's safe to be kept using.
What's the battery life of one of those masks?
It depends, up to 12 hours.
Up to 12 hours. Yeah, okay. So if for some reason, I guess it runs out midway, you've got other filters that people, other masks that people can swap into.
Yep. So absolutely, that's correct. So the battery pack is actually on your back.
Right, okay.
It's tied almost similar to a belt.
Yeah.
As well as the filter system.
Yeah.
And that's then connected via hose. But yes, absolutely, we at the storage at certain storage locations, we've got additional battery packs, we've got additional filters. It's always on standby. We do checks and balances to ensure that we've got enough for everybody to be utilised within each work environment where there's a high risk.
Thank you. Just a final question. Do you require your occupational hygienist to sign non-disclosure agreements?
I'm not aware of that.
Mhm.
I will have to take that on notice.
Thank you.
Thank you. Perhaps Honourable Mark Benazak and Honourable
Thanks.
Roberts? Okay. Yeah.
Thanks, Chair. Do you know, just to clarify, you do subcontract? You subcontract to other companies?
No, sorry, that's not correct. We are a joint venture partner
Right.
in a minority shareholder with principal contractors.
Okay. All right, so I can't ask you the same question I asked the other companies. Can I just go to the issue of vehicles? What came out in some of the documents that we got through an SO52 was the high prevalence of unroadworthy, unregisterable vehicles being used in tunnelling projects. Some with poor seals on windows, rags hanging out of petrol bowels, like the gas tanks. What processes have you got in place to ensure that all the vehicles that you use on your sites are roadworthy, safe, etc.?
Yes, thank you. So from the review and compliance checks that GELA partakes within the realm of our partners, I've never seen that, to be quite honest, in any of our projects where we've been involved in. The balances and checks that goes into any plant and equipment, inclusive of vehicles that come on to any of our projects, it's quite robust and it's set out in our health and safety management system. We've got predominantly we have a safety team that or an onboarding team that looks at every single piece of item of plant or vehicle that comes on board with a specific checklist of requirements, and those requirements are checked and maintained throughout.
Okay. I might reword the question I asked the other witnesses. What we saw through the documents that we got through the Standing Order 52 was a lot of high prevalence of breaches, which I would probably consider quite basic workplace health and safety errors, like making sure your mask is on at all times, your really basic stuff, and repeated. Have you, in your tunnelling projects, have you ever had cause to remove workers or groups of workers or retrain them for continued breaches of really basic work health and safety principles like that?
Yeah, Honourable Member, I'm surely aware of instances like that occurring. I have in the past been known to me that there has been instances where workers or employees have not, always complied with certain or specific requirements. But to my knowledge, supervisors or other employees or workers on the project normally pick up on that and provide advice to those workers normally within the sense of either retraining or picking them up on the spot.
Okay. Have you ever had cause to actually stop a project or pause a project because of those repeated breaches, or is it a case of you just push on and hope that the talking to works?
Yeah, no, I can certainly, to my knowledge, I do know of an instance at least where work has been stopped to ensure a safer work environment where breaches have been identified.
Can you give details as to how that occurred, where it was, for how long?
I'll take that on
and for
notice
what-
and provide you feedback. Thanks.
And for what, obviously for the reasons why it was stopped.
Yeah, of course.
Thank you.
Thank you, Chair. In your opening statement, you described the nature of the company as one that is, and these are my words, smaller than the principal contractors, and that you fit in, which is presumably doing work for and on behalf of the principal contract. So you sit separate from the principal contractor, but you have a commercial relationship with the principal contractor to do certain aspects of the project. Is that a fair way of describing how Gala operates? It's
Somewhat, but not
well,
completely.
perhaps, okay, that's what I understood. Could you please describe
Yeah, so
that?
in basic terms, it's a joint venture between
A joint venture, okay, right.
between different partnerships. Yeah.
Okay, so forgive me for asking these questions because we've
That's
been
fine.
hearing different explanations of how this works. So in terms of the joint relationship, that doesn't mean that you're subservient to the bigger contractor and therefore have to, dare I say, follow their lead. You operate in a joint fashion with them. Is that a fair way to describe the way the projects work?
It is fair. Having said that, the principal contractor's systems and or management systems are predominantly utilised to streamline the process.
Yeah,
Yes.
indeed. So this is where I'm taking the line of questioning. So, and we don't need to name individual principal contractors, but let's say principal contractor X is in a project with Gala, working on a tunnelling project. With respect to the principal contractor, do they place formally through the joint relationship obligations on how you carry out your part of the work given the relationship, or is that a matter that you just work out between yourselves outside a contractual relationship?
There's typically a joint venture agreement or a legal agreement that stipulates those requirements.
And if it's a joint relationship and a joint contractual arrangement, I presume, or I shouldn't presume, that in terms of meeting occupational health and safety standards, neither the principal contractor or yourself could ever find themselves in a situation where they fall below the minimum. In other words, the principal contractor surely must set the lead and insist on the regulatory standards, and of course you would follow that. That's a fair statement?
That's a fair statement to make. But having said that, as a minority or stakeholder partnership, that does not absolve us of having that same standard.
No, indeed.
Yeah. And in addition to that, our own health and safety management systems are also developed to the similar standard, although not always utilised.
Yes. So just following on then, are there occasions, and once again I'm not asking you to nominate companies, whereby you do find a situation where there could be a difference or a level of a debate between the principal contractor and yourself about occupational health and safety, and a tension arises, and there is therefore some debate over what should be done?
Look, I can certainly say I've
In general terms?
Yeah, it's been my experience that we've never had much debate in terms of a difference where we feel there's a lack of meeting a relevant standard or requirement. However, the process does work in a way that even prior to tendering and up to tendering, all partners are involved and given input into that development of the actual management systems related to safety that will be implemented in each and individual project. So we've got sight on that even before the project starts, and therefore we have that time and input right there and then, and throughout the whole process to completion.
Indeed, that was my next question. So to the extent a project got underway and was progressing, that there was some occupational health and safety matter that arose, and it was the basis upon which there needed to be some discussion about how to deal with it because of its complexity, and may not have fully anticipated in that negotiation. Do the parties come together, the principal contractor and yourself, and discuss that and work out how best to proceed to deal with the matter? Is that
Yes, Honourable Member, and absolutely that's correct. We, we're involved as much as we can, and in terms of consultation and participation between partnerships, that occurs daily on many levels. I can attest to my level in any way. We do regular site visits. We do annually, at least or less, site audits and inspections with our partners. We are also invited to project reviews. We receive monthly detailed updates and reports on the projects, not only monthly but as required. We've got a steering committee.
From who provides those reports to you, or what's the line of communication? Are you from the principal contractor back to yourself? Is that what you mean by reports?
Yes, correct.
Yeah.
From the joint venture.
The joint venture. Sorry.
Yeah. So we don't necessarily see the partnership in the joint venture sense as separate.
Yeah. Okay.
Contractually, yes, it's separate.
I understand what
but
you're
in
saying.
reality, we are one team. Yeah.
Now, with respect to the individuals that Geller engage to do the work, which is part of your obligation under the joint contract, are those individuals employees, direct employees of Geller, or are they contractors to Geller? In other words, what I'm getting at is, do you subcontract out perhaps elements of what you're required to do under your contract with the principal contractor to someone else to do part of the project that you've got responsibility for?
From a Geller standpoint of view, no, we don't.
No. So the individuals who are working for Geller are on a contract of employment. They're not contractors. They are direct employees of Geller.
That's correct, yes.
Now, with respect to those employees, would you mind just providing just an overview of the sort of the history of the practice of dealing with crystalline silicosis as an issue in tunnelling, and give us some insights into how it's been managed historically, if you could, and then some insights into how you're dealing with it now and what you might be looking for into the future to do to try and deal with this matter, just so we've got a sense of how the company's been dealing with this.
Yeah, certainly.
And I know that's a big range of questions, but I'll leave it to you to provide that view.
And look, I certainly do believe that, any area where there's a high risk, inclusive of silica in this case, we've always taken it seriously. I can remember, I've been with Geller for about the last 4.5 years, and I can remember I believe it was my first or second board meeting with Geller, actually related to crystalline silica, bringing that into, the business and saying, hey, we need to be looking at this. They're changing, the waste from 0.1 to 0.05. What's the risks? What do we need to do as a business? What do we need to be looking at as a business with our partners, etc. So it's been something that's always been dealt with as a concern, but as a reality to make sure that we stay on top of things. With regards to where we are at the moment...
But sorry, without sort of being difficult, that's going back, say, 5 years ago. That's sort of your experience history with the company. Are you able to make any comment about before then, when you took over, were you being told that this is an issue and needs to be considered, or that's history that you're not familiar with?
No, it's certainly history that I'm familiar with, albeit not that in depth, but I know it's always been a discussion topic, not as a singular item, but as part of a holistic risk management process that Geller has been working in, obviously because we're doing tunnelling works. So it's always been something that's been high on our priority list, whether it be in Australia, whether it be working in the US, working in Europe. It's dust exposure and silica has always been among our priorities to ensure that we can comply to those, mitigating standards.
In terms of the position of the company now in dealing with what is now a matter that's received much currency and debate, discussion, and indeed now appreciated concern about its impact, what is Geller doing looking forward to deal with this issue? Are you able to explain to that?
Yes,
to
of
us?
course, Honourable Member. And I want to also make it clear that Geller absolutely agrees with that. Look, it is an issue. We've been working on this for many years, but, I think we can, as an industry and, as partnerships, create a better line of communication between regulators, between unions, to ensure there's collaboration to work towards a common goal of reducing this risk of silica towards the workers on a work level. We, as a business, of course, with our partnerships, always look at ways on how to improve safety standards on projects. As I said or mentioned earlier, even before the update of the regulations, we have been implementing above and beyond measures. We have been looking at, implementing measures on a project level that's, beyond what is currently or has been used previously. And to that end, I think for the future we need to really, invest in looking at technology and ways of even, better providing input or providing a better risk plan for workers moving forward.
Can I just return to this theme about the nature of the relationship with the principal contractor and yourself, or what is a joint project? Have you found occasions dealing with this matter of crystalline silica where the principal contractor has put forward a ways and a means of managing it and dealing with it? I suppose first of all confronting it and then sort of dealing with it as an issue, and putting forward what they're doing and proposing to do. And Geller also, as co-partners, jointly doing this project, come and look at what's being put forward and find that it's actually lower or beneath what Geller would be wanting to do and perhaps does do in jurisdictions overseas. Have you ever been in that circumstance?
No, to my knowledge, we've never been in that particular position. But that, having said that, doesn't mean that we're always looking at ways to improve methods of operating safely on a project. We do tend to look elsewhere abroad at what's been implemented. Are there better ways? Are there different ways to bring, potentially over some of our projects in Australia? However, I've not been in a position where that's been actually the case.
And is it your evidence is that during this period leading up to the project commencing, that these issues are essentially worked out between the parties, the co-parties to the contract? Is that, based on what you've said a bit earlier, these matters are worked through during this period? Is that?
Yes, that's correct.
And I'm just conscious that we've nearly got to the time. Does Geller, with respect to the part of the project that it has contracted for, does it have, even on occasions, cause to use or be either required or needed to use equipment or aspects of, dare I say, hardware used or really infrastructure parts of the project which are under the control of the principal contractor? Or do you operate, I suppose I'll be clear about this, quite autonomously as a unit, and you've got your own gear, you know, very much self-sufficient, and just get about doing your part of the project?
No, so at no point do we have autonomy or are autonomous or separated through that joint venture, no.
Right. So how does it mesh together then? So let's take a piece of tunnel boring equipment. Would that be typically owned by the principal contractor? I'm trying to sort of work out in these co-joint arrangements what you're bringing to the project in terms of, other than the labour to do it.
Yeah, typically it's not just labour or workforce. We tend to bring expertise within the tunnelling industry.
Right.
But I mean, if you, I probably can't answer
As best you
correct.
can.
Yeah, where it comes to commercial contractual agreements, I'm probably not the best person suited to answer that.
No. But at the end of the day, the nature of the arrangement is that there's a contract there, but working as partners with the principal contractor, and there could be other partners as well. Is that correct? There could
Yes,
be other co-joint partners.
Yes, that's correct.
And they, at least in principle, are meant to be working in synchronicity with each other
Yes,
to complete the project.
My experience is that synchronicity is absolutely vital and key, and that is how we go about our business, is being at the same level as everyone else. And that's what I referred to earlier as we being one team on the joint venture.
Okay, well listen, we've just gone past 1:15, unless there's any other questions. Thank you very much for coming along. There may be some questions arising from the members reading Hansard following its publishing or its circulation after today, which might lead to some supplementary questions, which we'd appreciate if you could liaise with, or the Secretariat will liaise with you. So once again, thank you very much for coming along today.
Absolutely, and thank you very much.
Thank you. Okay. Well, good morning to you both, and I should say welcome back to this inquiry. The record shows that you both appeared on the first day to the inquiry to provide evidence in the capacity of your respective organisations, but also in a joint capacity as well in terms of Ms Cole's research work. So thank you both for making yourself available to come along again today. There's no need, therefore, to have you sworn. That oath or affirmation from the previous hearing stands, so we can pass over that. Can I invite, perhaps start this way, to invite you singularly or both to make an opening statement or provide an opening statement, and then if you're agreeable, we'll share the questions around. There's representatives from the opposition government crossbench, and the Honourable Stephen Lawrence is joining us remotely from Dubbo. So if you're happy with that, let's get underway and invite perhaps opening statements. If there's only one opening statement, that's fine, but the offer's there to both of you, so perhaps start with you.
Yep.
Thank you.
We'll do it separately. So I'd like to begin by acknowledging the traditional owners of the land that we meet on today and pay my respects to elders past, present and emerging, and say thank you for the opportunity to return and provide further evidence for this important review. Since I last appeared, I've undertaken a preliminary review of around 72,000 pages of documents obtained under the return to order. These documents from SafeWork New South Wales, Transport for New South Wales and Sydney Metro cover respirable crystalline silica in air data across 14 tunnel projects from 2016 to 2024. And at the first hearing, I said that the New South Wales Government should expect a significant number of lung cancer and silicosis cases from our infrastructure program. Unfortunately, the data that I have reviewed only confirms this concern. The data clearly shows that tunnel workers have been exposed to silica dust on New South Wales government-funded projects, and while exposure levels do vary between projects, some environments contained very high concentrations of silica dust over prolonged periods of time. Across the board, there were repeated instances of exceedances of the workplace exposure standard, including where workers were not protected by personal protective equipment. I've also recently finished analysing data from a national survey of people who have worked in tunnelling, with nearly 300 respondents providing insight into dust control practices in this industry. And I've commenced interviewing people to understand the barriers in silica risk reduction in tunnelling. I will acknowledge the work of Minister Kotsis in establishing the Tunnelling Dust Safety Task Force and to Safe Work New South Wales for progressing the long-awaited code of practice for tunnels under construction, and say thank you again for the opportunity to contribute, and I welcome your questions.
Thank you very much. Would you like to make an opening statement, Mr. Sullivan?
Yes, thank you. In early 2024, the Australian Workers' Union began requesting documents under the GIPA Act regarding silica dust exposure in New South Wales tunnelling projects. While Transport for New South Wales released key data revealing dangerously high exposure levels, Safe Work New South Wales refused, citing multiple reasons, including potential reputational damage to companies like CPB and John Holland. What should have been a straightforward transparency process quickly became obstructed by delay, inconsistency and active resistance. A small portion of the requested information was eventually obtained, and this is summarised in the AWU's written submission. Following recommendation in our submission, the Honourable Mark Banasiak MLC used Standing Order 52 to compel the full release of those documents. We thank Mr Banasiak for his decisive action. These documents confirm what AW members have long known: widespread breaches and systemic failure to protect health and safety of workers in the tunnelling industry. Key findings from those documents obtained through the Standing Order 52 include, but are certainly not limited to, workers on multiple projects being exposed to silica dust well above the legal limits, 1 in 3 tests on Sydney Metro, City and South West exceeding the WES, the Workplace Exposure Standard, some by 208 times. The Metro West, 1 in 7 tests breached the threshold. 13 workers from the M6 Stage 1 project have been diagnosed with silicosis. Companies knew that workers had to remove their PPE to communicate. Safe Work New South Wales failed to prosecute despite having evidence of breaches of the WHS Act since 2017. Regulators gave companies up to a week's notice before conducting safety inspections. The Australian Tunnelling Society sought to exclude unions from a national forum on silica dust safety discussions. This is not an isolated non-compliance. It is systemic negligence by employers like John Holland and CPB, regulators and government departments. Unless urgent reforms are made, this will become, and in fact already has to a degree become, a full-blown occupational disease crisis. So accordingly, the AWU recommends, and this is outlined in our paper as well, amending Section 118 of the WHS Act to allow WHS permit holders to take photos, videos and measurements when investigating suspected contraventions. Amend Section 230 of the WHS Act to allow unions to prosecute breaches of the WHS Act. Amend Section 232 of the WHS Act to extend the limitation period for prosecutions from 2 years to at least 5 years, and conduct a review as to the suitability of a centralised body to collect information modelled on coal services for all government-funded tunnelling projects.
Thank you very much. Perhaps I'll just open with the first question. I'll pass it to the Honourable Ron Roberts. The company involved in doing work in this area, a well-known international company, Acciona, has not made itself, at least at this point, available to provide evidence to the inquiry. I'm just wondering, with the work, and I'm just asking for a headline comment here, for the work that you've both done, does it actually cover work done with Acciona being a principal contract with any of the projects, or a contractor at all? in any of the projects?
Yeah, I can answer that.
Please.
So yes, it does cover projects that have been delivered by Acciona.
Acciona, yeah.
Yes, it does.
No, that's fine, thank you. That just helps give a bit of context, thank you. The Honourable Rod Roberts.
Good question, Chair, by the way. Thank you both for attending. I've just got a couple of questions to start with, and I may come back later depending on the time. To you, Mr. Donovan, first, right? In your opinion, the actions taken by the regulator, Safe Work New South Wales, were they timely and sufficient in addressing issues that have been found in the workplace?
I think they were almost certainly not timely and sufficient. I think one may have been led to the opinion that may have been the case, potentially, but there is very clear evidence now, thanks to the papers that we have, that is simply not true, unfortunately, and as a result, it would have impacted to a degree workers in the tunnelling industry.
Certainly. Well, to that regard then, what additional steps would you like to see in place to make the regulator more efficient?
Well, I'd certainly like to see...
Or steps that they should be taking?
Well, in terms of steps that they should be taking, I mean, the regulator clearly has the evidence that companies, some of the companies that have appeared here today, have been in breach of the WHS Act, and it is the regulator's job to regulate the industry, and as their power under the Act allows them to prosecute companies who fail to, or other bodies who fail to follow the Act. What's the point of having an Act of Parliament if they're not, if people who are going to breach the Act are not scared of being prosecuted?
So, more action then?
More action, more teeth.
Well, perhaps, more teeth, I agree with you, and perhaps we've heard from the regulator earlier on, and I think they're back again today, but a bit more stick instead of carrot, perhaps.
Yeah, definitely. And there's other examples of the regulator providing a week's notice to the company of them doing safety inspections.
We'd love that, wouldn't we? All of us in our various roles would love advance notice of what's going to happen.
Yeah.
Just further on then, what actions does your union believe is necessary to fully address silica dust issues in tunnelling projects? What apart from the regulator enforcing the regulations, which is their job to do, what other things could happen in the actual workplace to ensure it's as safe as it can practically be?
There's a lot of things for
you've got plenty of time, and here's your opportunity.
So the part of your question where you go to what things in the workplace could change, I think there's a large overarching fear of a lot of construction workers, particularly tunnelling workers, that if they speak up in relation to safety, that they won't be given access, that they won't, once that project finishes, then they may not be given work on other projects with the same company or with other companies, and that they'll be blacklisted. So I think to some degree there has to be a greater protection of workers in that space. Now, what's the solution to that is another difficult thing. I'm just sort of outlining a problem here and not giving you a solution, but just to give you an idea around the context.
Well, we need to know these things because, clearly we're here in this workplace, whereas the workers are at the coalface, to use that expression, who know and see the issues and related via you to us, so we can try and recommend perhaps various changes.
Yeah. There are other changes as well that could be made in relation to the union being a party to and employer groups being a party to the WHS Act. Some of the recommendations that I outlined there that may allow for suspected contraventions to be caught prior to them becoming an issue. And what the union has asked for is not anything radical. These laws already exist in South Australia, so it would just be sort of adopting best practice in this space.
Sure. Well, to that point, you touched upon it in your opening statement about regulatory and legislative changes. Would you just like to expand upon those just a little bit further?
Regulatory changes in relation to how things could be made better in tunnels.
Well, is there any legislative changes that you talked about in your
Yes.
opening submission?
Yes.
You said, it could be changes to the Work Health and Safety Act and various things. Would you like to expand upon that a bit more for us?
Yes, certainly. So, a union official is allowed to enter a workplace to conduct a safety inspection for a suspected contravention of the Act. And as I alluded to before, at the moment, that official cannot technically take photos or videos or measurements. And when I say measurements, I mean the measurement through, at least in the AWU's experience of taking measurements through a dust monitor that we purchased. Right now, all of those things are not technically allowable under the Act. So the photos and videos that the Australian Workers' Union has provided to this committee have in fact been done with an element of risk associated with doing that. But we believe, obviously, that it's our responsibility to make sure that these things are aired publicly. You might have heard comments this morning from other parties just in relation to dust monitoring. The Australian Workers' Union purchased dust monitors a number of years ago now, and as I think you're aware, those we were banned from going onto site to use those dust monitors. The company actually uses the exact same dust monitors themselves, so I think there needs to be greater collaboration in relation to what the union can do to assist this to becoming an issue before the regulator gets involved. We understand that the regulator, they can't be on every single work site every single time. We fully understand that, and so there is a role, as is stipulated under the Act, for unions to play a role in safety on site. And we believe, at least in this situation in tunnelling, that may assist. In relation to the other suggestion that I made in relation to amending Section 230 of the WHS Act to allow unions to prosecute, the regulator's not going to do it. Why shouldn't it be the case that a representative of a party who's an employee of the Act that's been breached should not be allowed to prosecute? I think that's just stifling the stifling policing of the Act, in my opinion. And the other recommendation was around changing 232 of the WHS Act to extend the limitation period for prosecution from 2 years, which is only 2 years under the Act, to 5 years, or I understand the statute of limitations more broadly speaking, maybe 6 years as well, but I'm not 100% sure on that. But extending that period from 2 years to 5 years would allow the regulator or whoever may be allowed to pursue legal action in this case to actually do that. We find that people may be diagnosed with silicosis. They might not find out for many years, and as well the Parliament or the union may not find out that in fact the company has breached the regulation until after 2 years anyway, which has been the case with some of this information that we've been provided. So to some degree, the regulator is sort of caught in that sort of space, but keeping in mind that they did themselves have the information readily available. Perhaps not the information that Transport for New South Wales had, but they themselves didn't have that information.
Thanks. And just changing to you, Mrs. Cole, just for a question. You talked in your opening submission about doing research in relation to the barriers that to try and prevent exposure to RCS.
Yes.
What are some of those barriers? What have you discovered by your surveys and your questioning and your reviews?
So, through the survey and interviews, I've been asking participants what they are, and the top 3 that have come out as sort of the top 3 barriers that have prevented good dust control in some of the tunnels in the state the first is leadership, which relates to safety culture, so not prioritising the issue at a project level. The second is lack of enforcement of regulation, which just leads to, I guess, the feeling that if the regulator isn't enforcing the issue, then maybe it's not a problem. And the third is time or schedule pressure. So prioritising other areas over health and safety.
Okay. Well, I might just leave it there for a moment, Chair, and give others opportunity.
We've got plenty of time. Honourable Susan Carr's joined us, so Honourable Susan Carr, and then I'll get back up board. Sorry, Susan.
Thank you. Thank you both for being here. Mrs. Cole, if I could just maybe pick up where my colleague just left off. I'm interested in your discussion of leadership as a factor or as a barrier. have you, in your research, have you seen, when you're talking about leadership, is it corporate leadership or is it project leadership? So, for example, the same contractor, are there different approaches to safety? Is it project specific or culture of safety more broadly?
So that's a great question, and the information that's coming through is that it's largely related to a project level leadership.
Mm-hmm.
So someone on the project that really prioritises worker health, prioritises safety, no matter what is happening, always puts safety first. That is not necessarily consistent across industry regardless of the principal contractor that is there in place. And so that was, the number one factor that came through that contributed to whether things were going to be protective of worker health or otherwise.
Mm. And as I understand these very large projects, there will be a head contractor, there will be multiple subcontractors. Does the safety chain fall down at a subcontractor level, or if the leadership at the top level is in place? I mean, can you talk a little bit about exactly where the problems arise?
So I don't have information on the exact sort of level of
Mm-hmm.
leadership, but I will say in my experience that if you have a very strong project manager, a strong project director, a strong construction director, that all comes from the top and it trickles down, even down to the subcontractor level. I mentioned in my opening statement that there were projects with sort of high exposures and some that were actually managing this quite well. And so I would anticipate that leadership has at least something to do with that. It's evident that this issue is not managed consistently across the entire New South Wales tunnelling industry. And in my own experience, I know that there are some very good leaders in this space that, take no prisoners and make sure that everything is going well. But equally, there are others that evidently have not done that within their own projects.
I'm conscious of the difficulties that you've had in accessing readings and material. And I understand that you have documentation in relation to air data. Do you also have documentation in relation to the PPE that workers had when there were those exceedances?
Yes, in most cases, the information that was provided included qualitative descriptors as to whether workers had access to respiratory protection, were wearing it, if they were clean shaven, if it was the right type, for example, and what type it was.
And so have you been able to map the levels of RCS against the PPE that was available to workers?
Yes, I have information as to how effective PPE was when the exposure standard was exceeded across various projects. And obviously, some projects have a lot of results that are above the workplace exposure standard and also have a lot of results where those workers were not protected by respiratory protection. And conversely, there are projects where most samples are below the workplace exposure standard, and where respiratory protection was used, that it was used effectively. So yes, I have that information.
And do you have any data on the length of time that there were exceedances? Like, are these unusual flare-ups, or it's a consistent pattern across weeks?
Yeah, that's a great question, and it really comes back to the types of work. So there was one instance where, even as recently as, say, 2023, there was a piling contractor on one of these tunnel projects with really high exposures to silica dust, like over 1 milligrams per cubic metre. And you think, okay, that's an issue. You'd think it'd be investigated and it wouldn't happen again, but then it happened again the next month. And similarly, in the Australian Workers' Union submission, there was a graph showing exceedances that related to road header operators and their exposures to silica over time. And it's not one exceedance without the appropriate respiratory protection. It's around, from memory, 7, over a period of months, which suggests that this is an issue that has not had the appropriate level of attention to stop those exceedances, or those exposures to workers happening over protracted periods of time. I will say that there is a very big difference, and the data is somewhat limited, in that the majority of the information that was provided under the Standing Order 52 came from Sydney Metro, who I presume have appropriate contractual requirements to obtain or receive that information. And very limited information was provided from Transport for New South Wales. So there is not much information relating to Western Harbour Tunnel or indeed the M6, because I guess that Transport don't have a systematic approach to request or receive that information, because if they did, it would have come out in the Standing Order 52 documents.
Okay, thank you. And with respect to exceedances, is there always a form of PPE that can protect regardless of the level, or are there just some levels against which all protection will fail?
That's a good question. So the PPE isn't infallible. So it's not going to be appropriate, it's not going to protect against absolutely everything all of the time. It's not going to protect it to zero. We're talking about a known human carcinogen. So it's not just silicosis, even though I know we focus on this a lot. We're also talking about lung cancer. And I know we talk about the workplace exposure standard as some magical limit, but we also know that adverse health effects happen below this limit. And so if we're just assuming that respiratory protection or PPE is controlling everything to this limit, it's sort of doing a disservice to workers, because we're still putting them at risk of silica-related diseases, including lung cancer. Now, I will say, to answer your question, in the exceedances that I've seen, based on the workplace exposure standard at the time, yes, there was always something that could have been done, but I would argue that when we start to see exposures of crystalline silica dust over in whole numbers, so the exposure standard 0.05, and we start to see exposures 1, 2, 9, 10 milligrams per cubic metre, I would argue that PPE is not the first thing that we should be going to in that instance, and that it just speaks to the importance of engineering controls like ventilation and dust suppression more broadly.
Okay, thank you. Mr. Donovan, if I could just ask you one question. You flagged that the enforcement changes that you want to see were in place in South Australia already?
One of the provisions in relation to permit holders, I believe, is already existing in South Australia. Yes.
Right, so it's only one of the provisions. And
Yes.
how long has that been in operation in South Australia?
I think I'd have to come back around approximately 6 to 12 months,
Okay.
approximately.
Look,
Yeah.
I wonder if you could take on notice. I'd be interested to know what, if any, effect that legislative provision has had on culture of safety, on enforcement, on worker safety in South Australia.
Sure, I'm more than happy to give. I may not be able to provide you information though in relation to tunnelling projects, although there is one in Adelaide that's coming up, but more generally I could provide that for you, yes.
I think the question really goes to, is there experience that this has been a positive change in South Australia? Okay, thank you.
Yes.
Rebecca Boyd.
Thank you very much, Chair, and thank you to both of you for coming along again to give us the benefit of your expertise and knowledge. Can I just start with you, Mr. Donovan, in relation to the case that the AWU were running against John Holland in relation to the, it was in relation to the Western Harbour Tunnel, wasn't it? Was it
I understand that it was, yes.
Yes, so I think we were all a bit keen to see an outcome from that case because it was a bit of a test case for the right to entry. I'm aware that litigation's very expensive. From what they were saying this morning, it seems to be that case has been sort of settled in some way. Are you able to, I guess, comment at all about the response that was given by the representative from John Holland today, and whether there has been, I guess, something good coming out of that case?
Whether or not there's something good coming out of that case, arguably yes. I think the representative from John Holland indicated that there was some arrangement made whereby they would allow the Australian Workers Union to enter tunnelling projects with the use of the dust monitor in certain circumstances. To that end, I imagine that that's a relative benefit. However, I mean, if we're talking about the overarching benefit that is, I mean, it in a sense restricts us to some degree, because on sites where we can just simply go on and use it, those companies could just point to an arrangement, a case with John Holland where access to use the monitor is restricted.
Yeah.
So it's not the best case scenario. No, it's where it's landed is my understanding.
Okay, thank you. Can I ask you? They also, the representative from John Holland was also talking about how they're now very happy to release the information. I guess, can I ask you, Mrs. Cole, first? I mean, you have a lot of experience trying to get information out of various government bodies around the country. Did the evidence this morning ring true for you in terms of their reasoning for wanting to hold back that information on the basis of not wanting to give the names of workers?
Look, it's my understanding that, I will say that when I did request information through Freedom of Information to a number of regulators, in every request I have always made it really clear that I do not seek data on individual workers' names or indeed any information that may make them identifiable. That was very clear in every single request. I guess I don't really want to, I can't comment on the evidence that was provided because that was the evidence provided by that company, but it's inconsistent with the information that I have received is all I guess I could say. Because the reasons that have been provided to me by tunnelling contractors that restrict or aim to restrict the access to information relate to potential reputational damage in relation to that release, which I find really interesting, because if the silica dust in air data shows low levels of exposure, why would it impact the reputation of a tunnel contractor? I've come at this research very open-minded and very hopeful. I am a perpetual optimist that things are much better now than they were historically. So maybe I was naive in thinking that this would be a relatively easy process, but that has not been the case. I point to an existing case where I've tried to access information from Queensland, and the tunnelling contractors have again restricted my access to that information, citing reputational concerns. And so that is a matter that is currently scheduled to be heard by the Queensland Civil and Administrative Appeals Tribunal just to get access to silica dust data in air from a recent tunnel. So I think it's wonderful that there is this newfound feeling of wanting to release this information, because I firmly believe that it shouldn't be kept private. In fact, in this state, I think that all silica dust in air data should go to a centralised body. In New South Wales mining, we have Coal Services, which is a fantastic institution which does independent monitoring, and all the monitoring goes back to that particular statutory body. And that is used for a range of purposes. One, to understand compliance, another to understand potential claims or provision of claims, and thirdly for research purposes. And without that structure within infrastructure or tunnelling more broadly, it relies on people like me or others to then go through that whole freedom of information process, which takes up to 12 to 24 months to access information.
And if you're also having to potentially go to court, that is a long period of time before you get the information. How does I guess maybe it's a question for you as well, Mr. Donovan, but the current statute of limitations of 2 years under the relevant legislation, do you think that that's playing in here? So, the cynic in me would say, if I was a company, if I could just delay the release of this information for 2 years, then you're not going to get sort of pinged for it under the Act, because it will then be a bit too late for that. Do you think that's part of the problem here?
Maybe I could answer that. Probably in this context, I don't think so. And the reason I say that is that I'm asking for information from work health and safety regulators. So they already have this information, and I'm asking them for it. You know, in the Standing Order 52, there was many documents from Safe Work New South Wales that demonstrated that they knew the levels of silica dust in tunnels across Sydney. In fact, a lot of the information from the road tunnels came from Safe Work New South Wales, including information where they had monitored silica dust in air exposures to their own inspectors as part of their duty of care. So I don't necessarily think that may be a part of it. I guess the newfound cynic in me may presume that it does relate to reputational impacts, but I really had hoped that recent tunnel projects would be the benefit of the knowledge and expertise of the engineers in our industry to create safer workplaces for tunnel workers.
And when just going back on that personal information, because it's bothering me, this personal information idea that, that's why we're not releasing this air monitoring data, but what personal information does it show anyway? Like, what is it that what could possibly be coming through in whether or not there's been an exceedance?
So the types of personal information that's present in the reports provided in the Standing Order 52 return to order that has been redacted is a worker's name.
Right, because they were carrying the device, or they were...
Because they wore the device.
Okay.
But I will say that there is an increasing trend in these air monitoring reports not to include the worker's name, which is fine. It's in other documentation, which is linked somehow, so they do know, but it's therefore becomes less of a problem in redacting it because it's not there to start with.
Given that the government is kind of the giver of this work, it's a gift to the construction industry whenever it decides to build a tunnel. We put it like that. It's not like there's other sort of players in that market, I guess, competing for that construction contract. So, as from a sort of buyer perspective, presumably it is then within. It's a bit of an obvious question, but it's within the government's power to just write it in as a standard thing into contracts that any construction company needs to be providing this data very publicly and very quickly as part of that contract. And if that was the same across every contractor, presumably that's just a really obvious way to exercise government control to ensure this would happen.
Yeah, absolutely. And I guess I'd point to a good example that is undertaken by Sydney Metro that does include those types of contractual requirements in each and every contract, at least since the City and Southwest project and still in the West and Western Sydney Airport contracts, where they are going above and beyond the regulation and putting in really specific requirements for contractors to meet, including giving them copies of air monitoring data. To your point, though, the extension of that would be that it would then also be provided to another centralised body, whether that be iCare, Dust Diseases Board or other appropriate institution. And there was many examples, I will say, in the Standing Order 52 return where that government client had issued contractual notices to tunnel contractors saying, but you haven't met these contractual criteria, you haven't given us the air monitoring data on time, you've exceeded the exposure standard, you've exposed a worker, what are you doing about it? So that precedence, I guess, exists, but that doesn't exist in transport for New South Wales. So the issue is managed differently, which is interesting because the exposures to workers are higher on transport projects because they use mine tunnelling and road headers more often. So the level of exposure on average on transport projects and the number of exceedances of the WES and exposures to workers without using respiratory protection is much higher on transport projects than it is on metro projects.
The representative from John Holland also sort of started their opening statement by talking about controlled and uncontrolled exceedances, and I know the Chair touched on this as well, but there seemed to be this argument that only the uncontrolled exceedances need to be notified. Is that correct? Can you talk us through sort of what that means and so I guess what you think of that statement?
So since the 1st of September last year, there's been a requirement for all exceedances of the exposure standard. Controlled, which means was wearing respiratory protection, or uncontrolled, meaning wasn't worn or not worn appropriately or not right type, for that to go to Safe Work New South Wales. Prior to that, there was no requirement for a business to notify the regulator. So the regulator may have obtained, or in the case of tunnelling, did obtain this information through a Section 155 request or a notice to contractors to obtain it. There is, in some projects, an increasing trend of those uncontrolled exceedances getting less and less. But that trend exists on metro projects, and it's difficult to understand if that trend exists on transport projects. So in the very early projects, there were a large number of exposures to silica dust without them being controlled. So either no PPE or the inappropriate type of PPE, or it wasn't worn correctly.
There was also, sorry, one question that I'll
please,
allow
okay.
people to ask, sorry. The other thing that both of the companies in the first session this morning were saying was that, I guess I was trying to get out of them that there was some new approach to ensuring that these that the risks of silicosis is managed in a better way, and there was a talk of the use of PAPR masks as being a sort of one of the advances of making that more standard. What's your kind of view on, like, we know that they're not the first line of defence, but what is in practice, what is the reality of what it looks like when someone's wearing one of those masks and how effective it really is?
Well, I think I need to be clear to the committee here. I know that there was evidence provided that maybe their use has been mandated since around 2022, or maybe I got the year wrong, around 2021, 2022.
Yeah.
But the VersaFlow line of powered air purifying respirators was launched 16 years ago. And prior to that, they existed just under another name. Indeed, when I started working in tunnelling around 2012, 2013, they were used by some road header operators. They have always been there. The issue has not been around the availability of this technology. The issue has been around prioritisation and cost. So from memory, they may cost around $2,000 or $3,000 each, as opposed to a P2 dust mask, which, I don't know, less than $20, I'm guessing, each. So, yeah, the issue has not been about the availability. And while it's really good, I would say, that contractors are providing these, this is a good thing. The challenge is that the heavy reliance on personal protective equipment kind of takes the eye off the ball on keeping a safer workplace or improving the workplace environment. Because if one only focuses on uncontrolled exceedances, then you have this risk of just the general level of silica getting higher over time. And I recently did a trend analysis of that, and I found that actually silica levels in some work groups are going up because they're focusing so much on personal protective equipment. And as you would know, the hierarchy of control is all entrenched or focused on providing the highest level of protection to workers. And this is a problem because when there is a breach, for some reason, the visor is lifted because there's not comms. And by the way, we've had communication systems that can be integrated into powered air purifying respirators for some time so that we can talk through radios. That technology does exist and has existed for a while. So when the focus is on these breaches, it's very much at a worker level on disciplining or going through that process of what did the worker do right or wrong, and less about what could have been done in that workplace to provide a safer workplace, better ventilation, better dust suppression, more higher level engineering controls.
Thank you. Come back to me if there's time.
No, thank you, Abigail. Might invite Honourable Stephen Lawrence, who's appearing for us today remotely, if you've got any questions you'd like to bowl up.
Yeah, thanks, Chair, and thanks to both the witnesses for their evidence. It's really helpful. The question I have for you both to consider answering is, I'm aware that you've been present throughout the morning and heard the evidence of the three companies, and I'm just wondering, and you've already done this in some respects, but I'm wondering, are there any comments that you wish to make regarding the evidence provided this morning from the three companies?
I might start. Is that all right? I think I might just focus on one point. So a previous witness spoke about the importance or the reliance on independent certified occupational hygienists and ventilation engineers. And this is a really, really good thing. But I need the committee to understand that neither of those positions generally have accountability or authority. So unlike New South Wales mining, these are not statutory positions. And I have experience in this myself, where I've been a certified occupational hygienist engaged on a tunnel project, and I know very well that I can make recommendations for improvement, and the ventilation officer or the ventilation engineer can also make recommendations for improvement, but that advice has not always been taken up because there is no authority or accountability to that particular role. It's not a statutory position. So I don't want to say that all tunnel contractors ignore the advice, but I will say that it does happen. And so making those roles statutory positions in legislation would actually go a long way, just the same way as it is in New South Wales mining.
Thanks, Ms. Cole.
Mr. Donovan, anything that you would like to add in terms of, because we observed that you were sitting here earlier today in the public gallery listening to the evidence from the 3 contractors that have brought evidence before us today. Is there anything that you'd like to comment on in regards to that evidence you heard?
Oh, look, I think some of the concerns that I had were raised in questions by members of this committee. One of them was just in relation to personal information, seeking personal information from requesting public information through the GIBRA Act. And there was at no time that when the union was going through this process that we're seeking to get personal information whatsoever. Our applications were simply to obtain information about what we believe to be breaches of the WHS Act in relation to dust monitoring. The names of people were of no interest to us, so I don't really understand why that was brought up as an issue, to be honest with you. And I think that it was mentioned by someone on the committee as to why they wouldn't actually, why their lawyers wouldn't actually have a process to redact the names anyway and provide the information, given that it's supposed to be public.
And probably be aware of that fact anyway.
Yes.
Yes. Sorry, Steve, do you have anything else?
That's my only question. Thank you, Chair.
Thank you. Perhaps, if I follow on, if it's okay, with committee members. Mrs. Cole, in your opening statement, it was packed with information, if I could describe it that way, which obviously relates to the much work you've been doing. Obviously before you appeared last year, late in the year, and since. I'm wondering this, in terms of that work that you're doing, is this part of ongoing work you've got, which will presumably take further time to bring you to a position of producing, dare I say, a comprehensive document or report, or are you preparing as you go along summaries, sort of use that word, or sub-reports in terms of what you're finding? And the reason I ask is simply this, be very bold enough to say, I expect, subject to what committee members say, we probably would have an interest in, subject to your concurrence, having a look at that work. Now, if that's not possible because it's part of a sort of ongoing exercise, so if you could perhaps just let us know, because I won't press it further if the position is you are in fact doing a piece of work which has a conclusion.
So I am in the process of publishing various papers that relate to various chapters of my PhD work.
Right.
So it will be published progressively over time, but that does not prevent me from providing information that would benefit the New South Wales Government in the development of policy that aims to protect the health and safety of workers in any way. So if there's any information that I have that would benefit the committee, then I'm more than happy to take any questions, including any questions on notice that may best inform you.
Thank you. That's very helpful, and I appreciate that response. Just some further questions. On the issue of the capture of the dust and then the exhaust systems, or the extraction systems to have the dust removed from the tunnels, that's obviously dust that's being exited out of the tunnels somewhere. I'm interested in to the extent you're able to assist us, tell us where that dust goes. Because obviously to have it extracted and removed from the tunnels is very good with respect to the very significant interests of the workers in the tunnels, but where does this dust go?
That is a great question. So it depends on what's being done. If I think about shafts or the building of shafts, that dust will go straight up into the atmosphere unless it is captured at the source. In fact, there was an example, I think it was last year, where a worker was exposed just from being located near the top of a shaft, and the amount of silica dust coming out of that shaft resulted in him being exposed to, I think it was around 1 milligram per cubic metre of respirable crystalline silica, and he didn't have any respiratory protection because he was above ground, so he didn't think he needed any, I'm guessing. So that was uncontrolled release of respirable crystalline silica out of that shaft and then into the work environment. In a tunnelling scenario during production, the air is typically exhausted into a very large spoil shed. So it's extracted at the face through scrubbers, which is collecting the majority of the dust. But as you probably also know, there are back-end works, so there are work activities happening not at the tunnel face that may produce dust, and that dust is then carried up into a spoil shed, which is one of the reasons why that workers who are located in those spoil sheds are still at risk of high levels of exposure to silica dust, because that's where it's contained. When those doors are opened, I would presume that it leaves those doors. The priority is always, or I'm guessing is always, on extracting the dust at the source, at the tunnel face.
Yes, because that was the, you've gone straight to the second point that I was going to raise, and that is that the collection of the spoils is in fact retained in big sheds, and the reason I know that is I drive up the Warringah Freeway home every night. I'm in the Parliament, and there's a very, on your left-hand side, huge spoil shed with big signs, AC owner, which obviously have responsibility for the shed. And I note that that shed on occasions is vacant in terms of nothing in there, but then on another occasion, it could be later in the day when driving home or not, whatever, it's full of spoil. And I've observed on some occasions work being done in the shed where that spoil is being loaded onto trucks and taken away, presumably somewhere. I mean, I do not know. That might be another question to ask in a moment. But I've noticed a lot of dust being created in the loading of the spoil into the trucks. So this is a lot more than just the capture downstairs, so to speak, in the tunnels. This exposure of dust does make its way up to, obviously, the surface and the workers in proximity of the surface. I want to ask this question now. With respect to that spoil, do you have any knowledge about where that spoil goes?
Sorry, specifically on that one, I'm not...
in general terms, so if I draw back from that example, in general terms, do you know where spoil goes?
Generally no, but I just wanted to touch on what you mentioned in the lead up to that question, which was in relation to the dust levels in those sheds. Some of the observations that we've had and that we've actually confirmed when we have used dust monitors is that in some cases the exposure to silica dust is actually higher in the spoil sheds as opposed to at the surface of the tunnel face. And I just wanted to make sure that that you were aware of that. But you're right in your observations, is that it is a messy area and there is a lot of dust, and the dust eventually does escape into the environment publicly, which I think might raise some concerns as well for, I don't know, residents in the area, maybe around Rosedale Interchange, where you have those houses that are very close. But in relation to where it goes, I'm not...
Yeah, I think that would just be a question for the contractors.
No, that's okay.
This morning.
Just sort of continue on this issue of the spoil sheds for a moment, if you're able to assist any further, it'd be appreciated. Do you know from the knowledge of the work that you've been doing in this area, from the point of view of the representative trades union and a person doing detailed research, that the people working in proximity of the spoil sheds, which would include also the truck drivers coming back and forth, that they are being provided with what would be required. Well, first of all, sorry, that any mitigation going on in regards to dust exposure in those sheds, and also provision of personal protective equipment and indeed education to them about the potential exposure risk they have. Any knowledge about that?
I will say that in my experience, a lot of the work that's undertaken in those spoil sheds is undertaken inside enclosed cabins, so in heavy plant, whether that be a loader, for example. So you have a worker that's there for an extended amount of time over that period of shift in a loader. And I'll just pick up a good thing, is that we've seen the increased use of pressurised and filtered cabins for loaders that therefore don't necessitate the use of respiratory protection in them, because those cabins are compliant with an appropriate Australian and international standard. So that is a good thing that we have seen. Conversely, that is not consistent across all tunnel projects. So where we have one that meets this international standard, we would have another that just relies on a standard loader coming to site, and therefore the worker is required to use respiratory protection, whether that's half face or a powered air purifying respirator for the extent of their shift. And this is the challenge and the inconsistency that we see in the industry. And I guess from my perspective, comes back to the desperate need for a code of practice to specify minimum criteria, whether that's ideally around heavy plant enclosures that meet the appropriate Australian international standard, through to ventilation requirements, statutory positions, etc. It's not until we get that level, I think, of minimum requirements that we can improve the level of compliance and therefore reduce the level of inconsistency that we see across the industry.
One more question and back to my colleagues. On the matter of real-time monitoring of dust, are you able to provide us with your best knowledge and technical understanding about what is available to do such monitoring from I guess, an actual technical point of view? Is there equipment out there that is capable of doing this monitoring and producing to a high level accuracy reportage of what the dust is before that it's monitoring?
Okay, I'll answer that. There are several brands, makes and models of portable personal respirable dust monitors that are available on the market. They have been around for a very long time. Whilst they do not directly measure crystalline silica, as the earlier witnesses provided, they do measure close to respirable dust, and we do use them routinely when we're investigating or assessing exposure to respirable crystalline silica, because what we do is we know the approximate level of crystalline silica in the dust, whether that's 50% or 75%, and we just apply a simple correction factor to that. And whilst it is not as accurate as personal exposure sampling, which is done, so it doesn't replace it, it is a very important supplement to it. And that is because it tells us in real time where failures in controls have happened, where a scrubber system is not working anymore, whether something's blocked or something's jammed or door seals no longer work. It tells us right then and there, such that the control measure can be rectified, exposures can be reduced, and we can move on. So that technology does exist. There is a real-time silica detector that I know is under the subject of a review by the Office of the Chief Scientist in New South Wales, and their report, I understand, is imminent. So I think it wouldn't be appropriate to comment on the accuracy of that until then, but that I understand that instrument not to be portable, so it sort of sits in a spot. So in tunnelling and infrastructure more broadly, it's really important that we have monitors that move where workers are located.
Please, no.
Just adding on further to that, when the union obtained dust monitors to actually go and conduct monitoring, it was one of those monitors that doesn't actually count. It can't indicate to you the level of silica dust or diesel particulate matter or any specific dust particle. But what we can understand is whether or not the dust is respirable. That's very easily done on the machine. And the main reason for it, again, just supporting what Kate's saying, that the union used it for, isn't to go to the company and point to the machine and say, oh, look, you're breaching the law. It's to go to the company and to say that your control measures aren't working in this particular space right now. Let's have a think about how can we, that the ventilation system up there isn't correctly set up, or the tunnel face has moved forward and it needs to move forward. So we do sort of try to act in that way to assist the project, and not to just sort of point the finger to say the law's being breached.
Yeah, thank you for that. Pass back to members again. Another cycle. Anyone like to jump in?
I've just got one question.
Oh, sorry, only one without hand.
Mrs. Cole, earlier you mentioned about giving, I suppose, statutory authority to hygienists. Are you proposing a separate statutory arrangement for the regulation of tunnelling, akin to what applies in mining?
Yeah, look, I think it's fair to say that the system that we have doesn't operate well, and it could operate a lot better. Like, we're not talking about engineered stone when we're talking about these cases of silicosis. We're talking about tunnelling which is serviced by Tier 1 contractors. This is the best of the best that Australia has to offer. This should be absolutely world class. And what the data demonstrates from the return to order is that this issue isn't managed in a world-class way all the time. Yes, there are areas where it's really, really well done. There are some fantastic tunnel projects out there, but there's obviously some big differences where it's not done very well. And I think because it is disjointed, the way we have this scheme, safe work, and this health monitoring process, which is separate, which is all very disjointed. It would be really wonderful to see something like the formation of a coal services or similar for the tunnelling industry, something where workers have health monitoring through that particular agency, where that agency receives data, where that agency goes out and does air monitoring independently, where that agency actually provides really useful and helpful information on trends to the regulator to be able to act on that information as appropriate to them. At the moment, it's very disjointed. So in terms of legislative reform, it's, in my opinion, a little bit bigger than a statutory position, even though that's, in my perspective, really, really important. Coal mining in this state has borne the brunt of poor control for many decades, and now has obviously established a really well-run scheme and an appropriate way of dealing with that very high risk to New South Wales coal mine workers. In New South Wales, we've been dealing with the issue of silicosis since the 1900s, and we've never really got it right. So I think in the light of the evidence that's been presented, particularly in the return to order for papers, maybe now is the appropriate time to rethink the structure and how it's all working, and that may include the establishment of something similar like coal services for the tunnelling and maybe infrastructure industry more broadly.
Does the RW have a view on that?
Yeah, we would 100% support it. Coal Services is probably a world-leading company in relation to that matter. We would definitely support it. Yes, because right now, as Kate mentioned, where the information, there has been some changes in the regulations about where information around silica dust exposure needs to go. So, for example, if somebody is diagnosed with silicosis, that information needs to be reported to the new registry that's set up. That's a national registry. So that may bypass or potentially bypass the New South Wales government or the New South Wales regulator and go straight federally. What isn't bypassed the regulator is the new provision around whether or not there is an exceedance of workplace exposure. That goes straight to the regulator now, but only if it's an exposure. Not all the monitoring that's done is provided. So while these new provisions are relatively good, it's a good step forward, they are a little bit disjointed in my view, and having something like a coal services equivalent for tunnelling, I think would just collate all of that information in a way that can really assist workers moving forward. And I think to some degree that we owe it to the workers who are going to be diagnosed with silicosis, and the lessons that we've learnt throughout the last 10, 15 years, particularly since this tunnelling boom has occurred in Sydney and in greater parts of New South Wales, that we owe it now to get it right for next time, because I don't see there being any slowdown from the New South Wales government, whether it's this one or whether it's another one, that will eventually happen for them to stop tunnelling projects, because where are you going to build highways in the middle of Sydney anyway? And then you have your other projects like your Snowies and stuff that's happening in Coffs Harbour and whatnot. So, to some degree, I think we need to look at it holistically like that as well.
Thank you. Honourable Susan.
Mrs. Cole, I understand that you've been able to model based on 3 Queensland projects. Was it easier to get access to information in Queensland? Do they do something different there that we could look to?
Unfortunately, it was incredibly difficult to get information in Queensland. The only way I could get access to information from the Clem 7, Airport Link and Legacy Way tunnel was that it was published in a response to questions on notice as part of the coal workers pneumoconiosis inquiry by Queensland Parliament. As I said, I'd hoped to actually compare the results of the study that I did with recent projects that were happening in Queensland, and unfortunately the tunnel contractors have worked to restrict access to that information, citing potential reputational impacts and other commercial impacts. And so that is a matter for the Queensland Civil and Administrative Appeals Tribunal at the moment. Unfortunately, I would have anticipated that exposures to workers in recent tunnels in Queensland and indeed any state of New South Wales would have been lower. So I would have loved to sit here in front of you today to say that, yes, it was 1 in 10, but now it's a lot better. But unfortunately, I can't. I will say that I haven't had an opportunity to do similar modelling on the Sydney, the New South Wales data, I should say. But I will say that on average, the exposures to road header operators, exposures to workers on foot building road tunnels and supervisors are actually much higher than there were on the Queensland projects that I modelled. So on that basis, it's still concerning.
Chair, if you don't mind, to that regard then, Mrs. Cole, you've obviously done a lot of studies across various projects. Is there one that stood out to you that was worse than any others?
Yes.
In terms of exposures?
Yes. So, based on the information that's come back from the return to order, the project with the most exposures above the exposure standard, the highest level of exposure and indeed the most instances where workers were not protected was WestConnect's M4 East. It's closely followed by WestConnect's new M5. I will say that I would like to provide a balanced view, if I can. I would like to say that the projects with the least results above the exposure standard and the lowest average exposures were Sydney Metro West, Western Tunnel Package and Central Tunnel Package.
Sure. Well, to that regard then, the M4 East, I think you said, was the worst with the highest numbers of exposures and that. Looking at that then, have you been able to identify a reason why there was much greater levels of exposure on that particular project as distinct from the other ones that you say were quite satisfactory? Was there a cause that you could find?
It's a very good question. I think a lot of it comes back to exposures to road header operators on those projects and exposure, dust not adequately in all cases being controlled at the source. It also comes down to using road headers that don't always have enclosed cabins, so open cabin road headers. And I will say that just on average, if we're looking at a subgroup within tunnelling that is most at risk, the exposures to silica dust to road header operators are on average 4 times higher than any other work group in underground construction in the tunnelling industry. And even though it might seem like that's a very small cohort, there were lots of road headers that were used across the West Connects, North Connects and other road projects in Sydney. So whilst I can't answer on specific factors, I would the averages and the exceedances are largely attributed to road header operators and those in proximity to those workers where dust has not been adequately captured by extraction and scrubber systems at the face.
Sure. Well then, in balance and in fairness, those projects that you talked about, and excuse me because I didn't write them down, those ones that were had lower exposure rates, what methodology did you see in place, and what restrictions and what controls were in place in those that made them, do you think, or provided for less exposure? Were the road headers used on those projects, for example, fully enclosed, as distinct from the other ones? Is there something we can look at in that regard?
So the exposures to workers on Western Tunnel Package and Central Tunnel Package, mainly they're using tunnel boring machines, and I thought, well, maybe that's the main reason why they're lower, but indeed the data does include exposures to road header operators, and they are significantly lower than those on the older projects. And so I can only anticipate that that is primarily due to greater controls around cabins, and indeed I think it was an Acciona project where they're doing remote controlled road header operation, so the worker is removed, which is a good engineering control because they're in a safe location that's operating the road header. And because the exposures are so low, regardless of PPE, it speaks to a higher level of engineering controls, ventilation, dust suppression, etc., that are already present in those work environments, such that if PPE is removed for a particular reason, generally it's not constituting a breach because the exposure is already lower. If that answers your question.
It does. That's all from me, Chair.
Thank you. I think I'm Boyd.
Thank you. Just one last question from me. Mr. Donovan, there's been, obviously since we've sort of started this inquiry, but more importantly, the SO52, the process, the work that you've been doing, Mrs. Cole, the media attention on this issue, have you or your members seen any significant change in approach from these big contractors as a result of that extra focus?
I can't give you a direct answer. I might have to take it on notice. I might have to take it on notice. Yeah.
I'm just wondering if things are getting better.
They're far more conscious of the issue of being exposed to dust and silica dust. That I know for sure because we have delegate training and they come in and we talk to them.
Yeah.
But just more broadly, I'd like to take it on notice. If
Thank you. You may need to take this on notice as well, but also, we've spoken a lot in this inquiry about the reticence that workers may feel about getting a diagnosis in the first place, about all of the sort of, the mental health issues that go along with this sort of exposure. Have you seen or are you aware of anything that the companies are doing to help with that side of things? If there is reticence from, even if there's things like, a sort of a tough guy approach to not wearing masks or some sort of, is there anything that companies are proactively doing to ensure that workers are actually kept safe and that they are getting help when they need it?
I think I'll have to go back and take that on notice again. Yeah, thank you.
Fair enough. Thank you.
Any others? Anthony? Stephen, did you have any that you wanted to bowl up at this stage?
No, thank you, Chair.
I've
Not at this stage.
one last one, if I may.
Thank you. Honourable Susan Carter.
A question to both of you. Are there models operating in other states that we can look to where things are better? I understand there's some different legislative provisions in South Australia. Queensland doesn't sound like it's got better access, but is anything happening in other states that would be good or instructive guides for us to look to?
I don't really think so. I think it's pretty bad across the board, but maybe Kate can talk to... sorry if I'm the one asking questions here. That's not really supposed to happen to Kate.
It was a question to both of you.
Kate has a broader understanding about international best practice, though.
Yeah, I can't say that any other state is better. Internationally, there are some really good models. In addition to the model of the New South Wales coal industry with coal services, internationally, Switzerland has a great model where tunnel contractors have to get workers' compensation by a specific certain agency called SUVA, and that agency also does air monitoring independently. And if air monitoring results are high, it results in an increase in insurance premiums for the contractor. Therefore, it's a direct financial incentive to keep dust levels low. And I will say that that particular agency also does the health monitoring. So it's all centralised. So it's similar to coal services, but the thing that is different is the immediate financial incentive. I will say that back in 1920, when we had our very first Workers' Compensation Act in New South Wales, which was obviously developed for silicosis, we had the same thing. So we used to have a committee that was funded by levies of silica dust generating industries, and that levy would fund this committee that would go out and do air monitoring. And if dust levels were high, it resulted in increased workers' compensation premiums for those contractors. So maybe it's time that we reflect on the past and what was put in place then as an opportunity to better protect workers.
Thank you. Any details about that Swiss model that you were easily able to provide on notice? I think we'd be very grateful.
Yeah, can do.
Thank you.
We're just about there. Just I might finish with this question. And I'll bowl it up as what's called a Dorothy Dix question, which I'm sure you appreciate what that means. We have this afternoon representatives from Safe Work New South Wales and also Transport for New South Wales giving further evidence. They both provided evidence previously. Are there any specific areas associated with this issue that we're tackling before us that you could suggest there could be more rapid movement? In other words, it's clear that there could be more rapid movement by Safe Work or Safe Work New South Wales and Transport for New South Wales to address some of these issues that we're facing. This inquiry is going to produce a report with recommendations, and we've heard evidence that obviously iteratively things are improving and all the rest of it. We accept that as a general statement, but right now, are there matters that can be moved on, pressed upon them to do, which arguably they shouldn't be delaying or dragging the chain? So I'll put that to you both.
Look, I did acknowledge the work of Minister Kotsis in my opening statement, and I'll reiterate it again. So the establishment of the Tunnelling Dust Safety Task Force is great. That's very good.
Yes.
I understand that Safe Work New South Wales are progressing the Tunnels Under Construction Code of Practice. Again, that is very good, but it needs to happen fast. It needs to be thorough and appropriate, and a large part of that Tunnels Under Construction Code of Practice must include a very large chapter on silica dust control, because the existing one, which is very old, is largely absent of the areas that are of most need. And when it comes to Safe Work, I understand that they are constrained by a statute of limitations of 2 years for prosecution. I would implore the committee to consider ways to extend that, because it's evident that there is information held by Safe Work New South Wales that there were high levels of exposures to workers without the use of masks. Whether or not 2 years is enough time to bring about a prosecution in that space is, I guess, a question for Safe Work New South Wales, but arguably extending it would only be of benefit. And to answer the second point around Transport for New South Wales, it was very evident, I think I mentioned before, that this issue is not managed consistently across government. You have Sydney Metro with very large contractual requirements, expert teams that are gaining compliance with those contractual requirements. And then over here you have Transport with a high level of risk to workers, absent of those contractual requirements and absent of experts in that area to gain any type of compliance with it, or indeed any systems in place to assure themselves of the levels of silica dust on their projects. So obtaining some type of consistency, arguably I would think that, you know, applying the metro model more broadly, because it's already been done and it's a precedence, would be an area of benefit for the government generally.
Thank you very much. And just to write it down quickly enough, it's tunnels under construction. What was the rest of the?
It's tunnels under construction, code of practice.
Code of practice. Well, once again, thank you both very much. It's been very informative and very helpful. I think there is some questions on notice, and I'm sure after reading Hansard, there'll be have some supplementary questions that we'd like to follow up as well. So if we're agreeable to liaise through the Secretariat to do that and have them return. So once again, thank you very much for coming along today. Appreciate it.
Thanks for the
Thank you.
opportunity.
Thank you.
Thanks.
Okay, well, we've broken a little bit earlier, making up a little bit for my misstep this morning. everybody to the afternoon and final session today for this inquiry hearing. We have witnesses next from Safe Work New South Wales, and I welcome them for coming along this afternoon. Now there is a formality to go through in terms of inducting the witnesses, but Mr. Curtin, your appearance before us last time, yes, going back now many weeks, in fact months, stands, so there's no need to have you sworn or affirmed again. But Ms Cox, we do need to do so with respect to you. So need you to state your name, your position title, and swear either an oath or an affirmation, whichever you prefer, the words of which should be there on a schedule before you. So welcome, Ms Cox.
Welcome, thank you. My name is Yasmin Cox. I'm the Executive Director for Regulatory Capability and Harm Prevention for Safe Work New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. So we'll get things underway. Now, just to let you know, there's representatives around the table, not all whom are back yet from their break, and that's an apology on their part, they've just been caught up, but we'll be returning. So representatives from the government, opposition crossbench. I'll invite an opening statement if you wish to do so, and then if you're agreeable, we'll move into the question and answer, and we'll be sharing that between the members of the table. So once again, welcome and thank you very much.
Yes, thank you, and good afternoon everyone. I've got a full opening statement.
No, that would be very helpful for us, yes. Please do. Yes.
So thank you for the opportunity to appear again before this committee to assist with this inquiry. I want to take this opportunity to update the committee on the key actions that Safe Work New South Wales has taken since I last appeared before the committee.
Thank you.
Since I last appeared, I visited a number of tunnelling projects and gone inside tunnels to see work conditions for myself across New South Wales. I've been able to hear directly from workers, HSRs, unions and project directors on the challenges that they are facing. I've also had the opportunity to see Safe Work inspectors in action and to experience the challenges they are facing in regulating these workplaces. It's important to me that I get this first-hand experience because it shapes my direction of Safe Work New South Wales. It's reinforced my belief that Safe Work New South Wales has a vital role to play to secure work health and safety, and that other parties also have an important role in ensuring worker safety in these government-funded tunnelling projects. I'd first like to outline how we've continued our compliance approach. Our inspectors have been continuing their targeted field inspections of all tunnelling projects across New South Wales, with a strong focus on assessing silica management systems and notifications of exceedances to the workplace exposure standards. We've conducted audits of all major tunnelling projects in New South Wales since November of last year. These audits have been undertaken at Metro West, Snowy Hydro 2.0, Coffs Harbour Bypass and the Western Harbour Tunnel. These audits are focused on the systems that monitor air quality and prevent silica exposure for workers, including ventilation extraction systems, water suppression and relevant work health and safety policies and procedures. To date, we've found that principal contractors have silica dust management systems in place that have been developed in consultation with competent persons, such as engineers and certified occupational hygienists. Principal contractors also have consultation arrangements in place to provide information to workers on matters regarding their health and safety, including silica dust management. During this series of inspections in tunnels, no notices for non-compliances for silica dust exposure were issued. Safe Work has also supported the New South Wales Government to establish the Tunnelling Dust Safety Task Force. Through this task force, Safe Work has an important role in developing greater collaboration and coordination between key experts on this issue. Safe Work New South Wales cannot secure worker safety on our own, and it's important that all parties in the tunnelling industry take action to protect workers. As chair of the task force, I've been pleased with the engagement of experts who come from a range of backgrounds. The first meeting of the task force was on the 8th of April, and an initial 10-point action plan has been developed. A communique has been published on the Safe Work website outlining the discussion at the first meeting and the agreed actions. Communiques will continue to be published as the task force meets and progress its action plan. I note that data is a key focus area for action. Safe Work New South Wales is publishing WES notification data. With the support of the task force, we've taken steps to make our data more accessible. Since 1 September 2024, it's been mandatory for PCBUs to notify Safe Work of air monitoring results where the workplace exposure standard for RCS has been exceeded. Quarterly information on the number of notifications by industry is now available on the New South Wales Government's Silica dashboard website. We will continue to work with task force members on refining the way that Safe Work collects data and to make more data publicly available. Key actions taken on by other task force members include making data available for sharing to develop new insights, supporting research, and for informing health screening. It's important to recognise that Safe Work does not hold all the data relevant in this area. It's held by various stakeholders, and collaboration is the key to bringing it together. The task force will play an important role in achieving this. More broadly, Safe Work is streamlining our processes around data access. I acknowledge the submissions made by unions to this committee that in their experience, it's been difficult to get data and information from Safe Work, including on notices issued after an investigation. As discussed at the last committee hearing, there are confidentiality provisions under the Work Health and Safety Act, being section 271. In brief, the section restricts the disclosure of information and documents where they've been obtained in exercising any power or function under the Act. There are exceptions to this, but applying these exceptions requires an evaluative judgment, and I can appreciate that in some circumstances in the past, Safe Work may have taken a cautious approach in applying the exemption. I'd like to see Safe Work move towards making data and information more accessible where possible. Due to the confidentiality provisions in the Act, it may always be necessary to consider on a case-by-case basis whether information or documents can be disclosed. We're also on track with the Tunnels Under Construction Code of Practice, in line with our commitment to this committee in November. About a third of the revised code has been drafted. Safe Work is in contact with experts to assist the drafting of those sections that are more complex and technical in nature. We aim for a renewed industry and social partner working group to meet in June this year to consider and comment on content for the new code. According to our projected timeline, a final draft code will be ready by the fourth quarter of this year, with the final code anticipated to be released by the end of the year. Effective consultation with workers is also another key element that needs focus. In my tunnel visits, I had the opportunity to meet directly with workers and health and safety representatives at the front line of tunnelling. Through my own experience and reflecting on the evidence from other stakeholders at earlier hearings with this committee, it's apparent to me that consultation with workers is critical across all workplaces, and in particular in tunnelling projects, where there are unique challenges for undertaking compliance activities. PCBUs have a duty under the Work Health and Safety Act to consult with workers who are likely to be directly affected by a matter relating to work health and safety. The focus on improving consultation will be reflected in the Safe Work New South Wales annual regulatory statement for next financial year, which we've recently commenced public consultation on. I've also observed that there are a range of challenges for the tunnelling industry. Securing work health and safety controls can be challenging in this environment. I'm pleased to see that my colleagues in the task force, Transport for New South Wales and Infrastructure New South Wales, have taken an action to lead a review of best practice engineering controls and other good practices in tunnelling projects to inform contract development and procurement processes to standardise best practice. This will help to ensure that best practice health and safety is considered at the very start of a project and how it may be separated from the competitive tendering process. The nature of the work also means that workers move through the industry and can often change employers. This can make it challenging to accurately monitor the health of workers over time and makes it difficult for Safe Work New South Wales to undertake investigations and prosecutions when diagnoses are reported. I appreciate the importance of following a worker's health throughout their career. Addressing this issue should see workers have improved access to their own health and atmospheric monitoring results. This was also a matter discussed with the task force, and my colleagues in Transport New South Wales and Infrastructure have also undertaken to review contract arrangements and procurement practices with industry to assess how they can be used to collect data and share relevant data. The Silica Worker Register will also be an important tool to track worker movements throughout the industry. Having finished public consultation on the Silica Worker Register late last year, we'll use the expertise of the task force to maximise the potential for the register and the data it will be holding. Silica Worker Register regulation is on track to be published in the third quarter of this year. Finally, I'd like to express my personal commitment and SafeWorks' commitment to continuing to take action on this issue, to collaborate with industry, unions and across government to secure safer work for tunnelling workers. I want to assure the committee that Safe Work New South Wales is focused on work health and safety risks in tunnelling. Every worker has a right to go to work and to come home safely every day. The risks are well known. The consequences of ongoing exposure to silica are serious, and SafeWork's regulatory response will be firm and focused. And I'll be pleased to answer any questions from the committee.
Well, thank you very much, Mr. Curtin. And is that a statement, a joint statement being made to above for the organisation? So you don't have a separate statement, or
no?
No, that's fine. So thank you very much, and listen, thank you very much for a very detailed opening statement. It is really appreciated. It's very thorough, and I have to say, I speak on behalf of myself, but I'm sure other committee members would agree that that's a very positive update report. And part of the reason of calling you back was to provide that opportunity, because we really did appreciate at the last hearing. By that stage, you'd started to pick up the reins and understand matters, but clearly much needed to be got on top of, so to speak, and you've been obviously very busy with your whole team, and a number of very positive things have been reported. So thank you very much. That's very, very good news.
Thank you.
So we'll start with the questions. Perhaps we'll start with Abigail Boyd.
Thank you, Chair, and thank you very much for coming back and giving us that update, which I agree sounds really positive. Can I take you back to the audit that was done of all the major tunnelling projects? And you say that there were no notices issued. Presumably they were, the inspections that were done with notice ahead of time. I guess what I'm trying to say is there, were the PCBs on their best behaviour because they knew you were coming, perhaps? Or was there any sort of spot checks done?
These were specifically targeted audits in relation to the exceedance reports that we've been receiving in relation to the WES. So being an audit-natured process, we were advising those projects that we were coming to check their systems of work, and the purpose of the audit was to check all of their silica management systems. In some cases, we issued notices to obtain those documents so that we could assess them in full. Alongside that, we've been doing a range of other visits to those tunnelling projects to look at the systems of work. Many of those have been unannounced, and many of those have been in response to the exceedances that have been reported.
Okay. And has there been any more sort of compliance notices or other things issued outside of that audit then in relation to exceedances, air pollution?
We've been undertaking a range of visits to tunnelling projects. We've visited all tunnelling projects many times across New South Wales. Many of those visits have been in response to exceedances and to work with those PCBUs to understand the investigations that they've taken and the actions they've taken in response to those exceedances. It is a very challenging environment, as I've said many times, for us to obtain compliance and to undertake our regulatory practice. Even an unannounced visit, you get to the front gate and there's a 30-minute at best, and in my own experience at least 30 minutes before you undertake an induction and get through into the areas where you may have been able to observe where poor practices might be occurring. When our inspectors have undertaken their visits of recent times, they have not observed any of those activities that have been of concern in relation to observing silica dust.
We spoke quite a lot last time with the union representatives, and I think we also touched on this in your session as well, but the obligation to consult with workers, and I think we certainly received evidence from the union representatives that they felt that the safest workplaces were where there had been the best consultation between workers and businesses to create a safer workplace, and they were worried that sort of duty to consult wasn't being respected in a lot of these cases. Have you done anything to sort of investigate that aspect to ensure that businesses are working with workers to make it a safe workplace?
Yes. So all workplaces have an obligation under the Work Health and Safety Act to consult with their workers for those areas where work health and safety affects those workers. Our inspectors in any organisation will undertake a review of consultation mechanisms to make sure that they're meeting the legislative requirements. In my own observations and conversations with workers and HSRs on these major tunnelling projects, they have raised concerns with me about the consultation mechanisms. I have spoken to our inspectors about making sure that we are lifting our approach in observing those consultation mechanisms, regardless of compliance with the law. And I would say, where inspectors are finding that these organisations are complying with our law in terms of consultation, I continue to recommend and have conversations with those project directors about enhancing consultation. I think one of the combats to the challenge that we as a regulator face in this particular environment is full and meaningful consultation with their workers, and a full and meaningful system of health and safety representatives and work health and safety committees that allow workers to meaningfully raise their concerns and have them addressed without any reprisal. We want to take up a piece of work, as I said previously in my opening statement, to make sure that strong consultation mechanisms are in place. And my recommendation, as I said, to those PCBUs is to think about enhancing consultation over and above their minimum legislative responsibilities. I think it's through those consultation mechanisms that we'll continue to find the challenges or the areas of non-compliance and we'll be able to address them more quickly. We will be hosting a forum or a round table or a workshop, if you like, with health and safety representatives from the tunnelling industry. It's one of the actions I've taken from the Tunnelling Dust Safety Task Force to make sure we're enhancing that. Across all industries, it will be a priority for us next year, but I think there should be an intensive focus on supporting HSRs in the tunnelling industry.
On the answers you returned to supplementary questions, there was a question about how many improvement notices have been issued in relation to tunnelling sites, and then sort of saying what the nature of the offence was. And I think in the last 5 or so years, there had been one issued in relation to consultation. There have been criticisms of safe workers not sort of using a stick approach sort of sufficiently and using a carrot approach sort of too much. What do you, I guess, can you give us some idea of what it takes to get an improvement notice issued for something like consultation, and how discretionary that is for each, I guess, who the inspector is, are they, I'm trying to get an idea of when they're issued, and whether there is scope to sort of issue more for where consultation's really not coming up to standard.
Yeah, forgive me, as I've said in this area before, I'm not an inspector, so I do my very best to explain, how best an inspector undertakes their practice. But as I best understand, an inspector will need to ensure that the PCBU has put in place appropriate mechanisms that demonstrate that effective consultation is in place with workers in relation to the legislative mechanisms. I think broadly where I've been into different industries and different organisations right across New South Wales, there is a clear correlation between those organisations that are open and transparent and consulting readily on work health and safety issues and safety outcomes, as well as production outcomes and good staff management outcomes. Going above and beyond compliance is what we really want to seek here. In terms of the actual issuing of notices, the inspector will do an assessment of the mechanisms that are in place. They'll ask questions or obtain documents under notice from the PCBU in relation to the consultation mechanisms that are in place. There's quite broad flexibility in the legislation around how consultation is done, and the workers are required to have a say in how they want to organise around that consultation. So it's important that we undertake a process to inform and advise workers about what their rights are in terms of consultation, make sure that PCBUs are clear about their obligations, and if there are any breaches, that we are taking action to support that. And I think the approach in the tunnelling industry specifically will be a key focus for us over the next period.
One of the things that came up in the, I think it was in the introductory statement from the John Holland representative this morning, was in relation to the obligation to notify exceedances of the WES based on whether or not it's a controlled or an uncontrolled exceedance. Are all of the companies notifying correctly of all of those exceedances, or is there an element of only having the uncontrolled exceedances being notified?
The requirement is to notify exceedances, so they need to notify all of those exceedances. We are attempting and working to improve the way we receive that information to try and narrow down where those exceedances are, as you say, controlled or uncontrolled. One of the concerns there is that there's not a proper definition for controlled or uncontrolled, so it's a little bit up to the PCBU to determine whether a controlled environment or uncontrolled environment was. I think these are some of the areas that, as we continue to receive more notifications, as we do our verification process against them to determine what are the mechanisms and how are those exceedances occurring, that we can tighten up these controls and get really clear about where it is an exceedance or where it is someone that's been exposed without, respiratory protection or similar.
Yep. One of the other things we spoke about last time was the uncertainty around how the obligation to monitor air quality was sort of implemented in practice. So things like how frequently you do it, whereabouts you have to do it within the tunnelling project, all of those sorts of things. And I think we spoke about, obviously we've got the tunnelling code of practice work that's been ongoing, but we spoke about maybe getting some of those things nutted out ahead of time, so that at least everyone was reporting on the same basis. Is that work that's been done yet?
It is work that we're exploring in terms of strengthening. I think the tunnelling code of practice is the right place to make sure we get really clear on the expectations about how that works. Our inspectors are currently doing some work to explore what better practice might look like in terms of setting out expectations for how that monitoring is done. We are concerned, or we should be concerned to make sure that there are rigorous and structured ways in which that monitoring is done, so that we know that it's being done in appropriate ways. I have, in my discussions with project directors, discussed with them making sure that their workers and health and safety representatives are a part of the process in designing how those systems are set up, because I think that's relevant for building confidence amongst the workforce that the proper monitoring programs are in place and that the workforce can feel comfortable that the results they're receiving are accurate for the environment that they're working in. So there is a role for safe work and for the tunnelling and construction code of practice to define that much better, but there's also a role, I think, for project directors and PCBUs to openly consult with their workers on how those programs are set out, so that they can have confidence that those right control measures are in place.
So obviously comparing data that's coming from very, different types of monitoring situations gets really difficult. We've spoken about how hard it is to get the data to begin with, and you've spoken about, new developments in trying to put that data out there a bit more easily. But will we also be given the details as to, this is the number of exceedances here, but this particular PCBU is only doing this every 3 months, whereas here's the number of exceedances at this one, and but they're doing it every day. Is there that level of transparency going to be available so people can properly analyse what's going on?
I would like to see us be more able to release more detailed information in regards to those notifications and exceedances. We are restricted by Section 271 of the Act, and I may have shared here last time, but I certainly will this time, that I think it's relevant for the committee to have a look how Section 271 interplays with the amount of information that we're able to release in relation to those exceedances. The purpose of us collecting that information, of course, is to review it and undertake compliance activities, but there's a public interest in where those priority areas are, where the types of work might be occurring, where workers are regularly being exposed to those exceedances, or which particular projects they might be receiving those exceedances. We'd also like to see some improvement, and we've put on the table at the Tunnelling Dust Safety Task Force an opportunity to see how we might be able to better collect that information for workers, so that they'll be able to see longitudinal over their career, their health monitoring results, but potentially even their atmospheric results. So I would like to see us able to do that, and if there are legislative mechanisms that are restricting us from making meaningful information available, I think that's definitely worth reviewing.
And are you having to use Section 155 of the WHS Act to get information from the Dust Diseases Authority about instances of silicosis being reported? Or is that something that comes to you directly from the PCBUs?
My understanding is we do use 155 notices with iCare to get information in terms of diagnoses of silicosis.
Yeah, okay. Would it be better if you had a direct reporting to you so you didn't have to do that?
probably it would relieve a regulatory burden, but it is a reasonably straightforward process for an inspector to issue a 155 notice, but it would make sense that we can have direct access to information that affects workers.
Pause there and give other people time to
Thank you.
come
We'll
back.
come
if
back
you
again.
like.
The Honourable Susan Keller.
Thank you. Thank you. Thank you both for being here, and thank you for that update in the opening statement. That was very helpful and encouraging, so thank you. I have some questions, if they're not premature, in relation to the code of conduct that's being developed. Is it proposed that this be voluntary or mandatory?
A code of practice can be used in court processes. So it relates to how we assess, as far as is reasonably practicable. If there's an industry code that defines a set of criteria, then our expectation is that industry are able to implement those criteria, and therefore it becomes part of our compliance activity.
So it's effectively then mandatory to comply with the standards in the code of practice?
It would normally be that a PCBU has to comply with that or provide a system that's better than what's outlined in the code.
Okay. And so what are the compliance checks then in relation to the code of practice?
The existing code of practice?
Well, what do you anticipate? Will there be any change in compliance checks with the new code of practice?
Yes, our inspectors have a responsibility to make sure that tunnelling projects are implementing control measures, and we often speak about the engineering control measures as far as is reasonably practicable. Where we see improved practices across industry, or we see it in other tunnelling projects, there's an increasing expectation that those improved controls are then standardised across industry. The code of practice is a documented way of setting out our expectations and the minimum standards required. The other mechanism is through the contractual arrangements at the start of the project. We are a big advocate for safety by design, and we'd like to see a standardisation of the safety mechanisms that are put in place right back at the contract phase. Many of the contractors that I've spoken to and our own inspectors would appreciate those mechanisms being put in place right at the very start of a project, so that there's a holistic approach to those engineering controls. We know that for some of the engineering controls, such as the scrubbers that many were talking about earlier today, they use an enormous amount of energy, and so power availability has to be part of the design process right at the start, so that the right engineering control mechanisms can be put in place.
So other than power availability, what are the other barriers to that safety by design occurring at the moment?
I think some of that comes to, and forgive me, I'm no engineer, but the design of how we build the tunnels in the first place is something that's considered at the contract design stage. The difference between a tunnel boring machine or a road header is, of course, a common discussion here. When I met with some of the tunnelling projects that were building roads, they indicate to me and can demonstrate that a tunnel boring machine is only appropriate for some parts of the project and not for other parts of the project. There are different types of approaches with pressurisation and using misting and other things in tunnelling boring machines, but I'm advised that some of those improved safety mechanisms will slow down projects from progressing. Slower projects cost more money. So as I understand, and forgive me, it's not my area of expertise, but as I understand that there is a cost versus project design element to the discussion that we're having.
In terms of those cost discussions, especially where the government is the client, is there ever a discussion about the cost of impaired worker health?
We are not in those discussions around the design of the contracts. SafeWork is represented in the Construction Leadership Group, which is a whole of government group that comes together to look at the issuing and the management of these contracts. We've been able to feed into that process some increased information in relation to safety outcomes on various projects. We've got a memorandum of understanding with Infrastructure New South Wales where they use a power in their act to obtain information from us about the safety outcomes on those projects. Really pleased to be able to provide that information because it should be an important part of informing Infrastructure New South Wales about how they issue contracts and how they manage contracts ongoing.
We've heard a lot of comment and a lot of criticism that current enforcement procedures, current inspection procedures are not really working. So what will be different about the climate with the new code of practice?
Our inspectors undertake an assessment of the conditions in the tunnels and the systems of work that have been laid out in as far as reasonably practicable kind of way. The code of practice will help us to better define, along with industry, those types of controls that we would consider best practice and required in these tunnels. We're also undertaking some work with the resource regulator. There are typically tighter controls in the mining industry than there is in tunnelling, and we'd like to see what parts of those control measures in the mining industry would be relevant to tunnelling and would help us to progress to safer outcomes. We are looking at improving our understanding of how the engineering of ventilation systems work so that we can make sure that we can continue to provide advice to tunnelling projects about what better practice might look like. And if there are, for example, a number of exceedances in a particular project that's not using a wet-based scrubbing system, we might have discussions with them or potentially issue notices to them to make sure that they improve their systems. If those systems are available to the industry and available across other projects and they're practicable, we might continue to see an increase. So the code of practice is the mechanism to get the best experts we can get our hands on to help design and define what those criteria are, to help our inspectors to be able to take a measured and structured approach in seeking compliance in those tunnelling projects.
Do you need additional resources to be able to enforce and, when there's been breaches, actually proceed against the parties who've been in breach?
We like any government department, we could always use more resources, but that's a matter for the government to determine. Within our existing resources, we've allocated inspectors to a dedicated infrastructure and renewables team, and the government has funded this year $2.5 million for a dedicated silica compliance team. We have significantly increased the number of inspections that we've undertaken in tunnelling projects, as well as across the broader silica industry, with engineered stone and other construction businesses. In terms of the compliance, what I've observed in my discussions with inspectors is the challenge that they face in this particular environment. It's much simpler to attend a construction site, see a worker working from height without the right control measures in place, issue a penalty notice or take some other enforcement action against that person or against that PCBU. It's a very straightforward approach. This is a very complex environment. It's underground, it's difficult to access. There are complex and mature systems that these large organisations have put in place and have developed over a long period of time. The mechanisms that we use in terms of on-the-spot penalty fines, improvement notices, prohibition notices and prosecutions are particularly difficult in this environment to implement. When inspectors attend a site, it's many days or weeks, but normally after the exceedance has been reported to us, activities might be changed in the process of the inspector arriving on site and getting to the point where those activities might be underway, and prosecutions are very difficult. We've got a statute of limitation, and we also find it difficult because of workers moving across different organisations through the life of their career to be able to say that this organisation for this period of time is responsible for that person's diagnosis of silicosis is a very, very challenging and difficult environment.
With respect to the prosecution issue, is the point in time when you want to be launching a prosecution at the point in time of the diagnosis with the worker, or is it the point in time of the breach by the PCBU?
Correct. Often we've been notified of silicosis diagnoses, particularly in the engineered stone industry, and we've initiated, as a result of that notification, we've initiated investigations and prosecutions, because that's the point where we've become aware for that particular PCB where the risk has occurred. For tunnelling projects, of course, the risk occurs over a period of time, and whether a breach has occurred or hasn't occurred is a matter for investigation and then for the legal process to determine it. It is a very tricky environment to understand when the breach or the risk exactly occurred, when the trigger for the statute of limitation starts, and then the investigation process with prospects of a prosecution is very difficult.
Do you have any recommendations about how some of those tunnel-specific issues could be better addressed in terms of framing of penalties, legislation?
Yes, I would welcome any recommendations from the committee to have a look.
I'm asking you if you've got any recommendations.
Well, I would, if you were to focus those things on, having an exploration of whether there are additional penalties that could be applied to PCBUs, My best understanding of the statute is that where an inspector sees a worker without their respiratory protection properly worn, that they can issue a penalty against that worker, but they can't issue a penalty against the organisation for ensuring that worker has the right respiratory protection on. We think that might be an opportunity to increase the opportunity for our inspectors to take immediate and direct action, for example. So areas for penalty notice would be worth looking at, and we think the statute of limitation for this type of environment, where we're looking at an occupational health problem, similar to the challenges that we're facing in terms of psychosocial risk in workplaces, where the statute of limitation was broadly designed around a time when we had more direct injuries and fatalities, and we could take 2 years to undertake an investigation and lay charges, that there might be an opportunity for the committee to make recommendations and consider broadening those statutes of limitation.
Can I just jump in on that
Thanks,
question?
Chair. Yeah.
Thank you.
So, you say that there's no capacity to penalise the PCBU. We've heard evidence around repeated breaches of the same nature. Surely that indicates an absence of a safe system of work, which would then provide an opportunity for the PCBU to be penalised. Isn't that correct?
In terms of penalising, in that circumstance, what we're currently exploring is reviewing those exceedances that we've received, particularly those ones that have been characterised as non-controlled, to see whether an investigation and a potential prosecution is the right pathway for us. We've been receiving those exceedances since September last year, and we're looking into the opportunity to potentially do
obviously, if it's a repeated
Yes.
occurrence, then the system is not working, and clearly there's a risk that's there that that should be that the PCBU should be aware of and should be mitigating to put in place a system of work that is safe, that anticipates the workers are going to and puts in measures to make sure that that's not a repeat occurrence.
Yes.
So surely the safe system of work is there.
We've been doing verifications on every single exceedance that has come in, and they all have a different kind of nature to them, or a different time, or a different work environment. But you are correct. Where we see multiple exceedances, we are currently looking into opportunities to investigate and potentially move to prosecution for those.
So back to you, Susan.
I'm sorry. I was. Yeah. No.
Can I move to the Honourable Stephen Lawrence, who's joining us by video link. Stephen, any questions you'd like to bowl up?
Yeah, maybe a couple. Thanks, Chair. Thanks, Mr. Curtin, to both witnesses, in fact, for your evidence. It's really helpful. Mr. Curtin, in terms of this work in these tunnels, is it work that is capable of being done in a safe way, assuming compliance with the various regulatory systems, the wearing of masks and so forth, or is there some factor that makes it inherently unsafe? Is there always going to be a percentage of workers who develop silicosis, for example, irrespective of what they do?
Mr. Lawrence, thank you. I think that's a very good question. We are choosing to dig tunnels for the purpose of prosperity and to improve transport across New South Wales, and our observation to this point that's been revealed through this committee and other working groups and task forces is that as a result of those tunnelling projects, workers are being diagnosed with silicosis. That's a matter of fact. What we're attempting to do is to work with industry, to work with unions and workers to find as much as possible all of the controls that are foreseeably able to be put in place to protect those workers from those environments. Improved monitoring has been successful in making sure that we can identify as quickly as possible where workers are being exposed, or where there are systemic ways that workers are being exposed, and we can put in place further control measures. I was really pleased to see on my visits to one of the tunnels that there was a remote piloting trial underway for a tunnel boring machine. It was for a road header actually. And I think opportunities for government to invest further, or for contractors to invest further in ways where we can eliminate the exposure that workers have to these dusty environments would be fantastic. To completely eliminate total risk of being exposed to dust would be a great challenge in this environment.
I mean, I suppose there's sort of two sorts of risks, isn't there? There's the risk that arises from the inevitable fact that some people, whether workers or managers, won't comply with what should be done. And then there's the risk that might exist irrespective of their compliance. So there is just still some risk. Is this a case of the latter or the former?
I think it's both. So in my observations, I met with a man who was driving the road header in a particular tunnel, and he was in an atmospheric controlled environment that was pressurised to make sure that dust that was being dug against the face wasn't coming into his environment. But he continued to wear a P2 mask because he had picked up dust on his uniform on his way in and out of the machine, and so he still had dust in the environment that was well controlled. So the engineering controls, as I explained before, sometimes are limited by other factors such as availability of electricity or other things. I understand that some of the scrubbing machines are designed for coal industry and might be working much better in that industry than they are in terms of silica. So there are much improved controls in place in terms of the engineering and in terms of the systems of work, and I think we're doing much better than we've ever done before, but there is more work to be done, and that's the purpose of the task force, to really explore and deep dive into what those opportunities are. And I'm really pleased to see Transport and Infrastructure doing that work. The work that my inspectors are doing, working with the resource regulator to try and find those opportunities out of the mining industry, is really positive. But at the end of the day, leadership, culture, consultation are really important mechanisms for making sure we see compliance. When I visit tunnels, I see a lot more people now wearing the PAPRs, the full respiratory masks, because I think the awareness of the risks that they're facing and their potential health outcomes are much more known across the industry, and they're looking to protect themselves much more than they have in the past. Those improved controls, whilst we acknowledge RPE is one of the lowest order controls, we want to see improved versions of RPE so that people are better protected in the long run.
Yeah. In terms of the causes of the silicosis, is the two main causes exceedance, so where the concentration exceeds the allowable limit, and also people not wearing masks? Is that the two main causes?
I think the exceedance itself is a measure of an increased exposure over the period of time that the monitoring has occurred. I think we can focus very easily on the idea that dust in your lungs is a really bad thing. When the dust has silica in it, that causes, that particularly fine particle causes particular damage to the lung. That happens over a longer period where workers are exposed to low levels of it over their entire career. But we know that we see those accelerated cases where people are exposed in those high-risk areas, like previously where we've seen road headers that weren't protected and RPE wasn't used many, many years ago. We saw those cases coming through much more strongly.
Yeah. And just lastly, could you give us a bit of an overview of criminal prosecutions of these companies involved in the tunnelling projects in Sydney over time?
Yeah, I can take that on notice. Most of our prosecutions in terms of silica have been in relation to engineered stone industry. We do currently have an investigation underway at the moment in relation to the workers identified at CPB. That's the main prosecution that's underway at the moment. But I'll take on notice just to make sure we come back to you with accurate information.
That's really helpful. Thank you. And thank you, Chair. That's my questions.
Thank you. I might just jump in with a couple myself, if it's okay. With respect to the work that's being done now, and from the evidence today, it's very positive about progressing and accelerating the way this challenge is being dealt with in this state. And these initiatives can continue to sort of follow their trajectory outwards. My question is New South Wales inhibited in any way from pushing out and doing this good work in this area by any of our obligations as a state within a federation and Commonwealth work in the area of occupational health and safety, and I'm thinking specifically at the safe work level? Because perish the thought that all the good work that has been got underway and moving forward does get, and I'm not saying there's any malfeasance behind this, but obviously the process of working laterally up across the federation is a slower process. So just on that particular point, is there anything that you can see on the horizon or in fact, has poked you in the eye already, which is a potential sort of bit of dead weight for us in New South Wales.
Yep, we are a signatory to the intergovernmental agreement, and I represent New South Wales as a member of Safe Work Australia. We in New South Wales have been pure to that intergovernmental agreement and been good partners across the Commonwealth in terms of legislative amendments. I have indicated to the Safe Work Australia membership more recently that at times I think that may have inhibited us from moving as quickly as we needed to. We have at times moved more quickly than the Commonwealth in terms of control measures in relation to engineered stone and other things, and I think we should be prepared to continue to move quickly where necessary to protect workers' lives in New South Wales. We can still do that and be respectful to the national context. We've seen other jurisdictions take action and amend their legislation outside that particular process. I think it's entirely a positive environment to have nationally consistent laws and to have model laws through that process, and we absolutely want to continue to pay respect to that, but we should not allow that to inhibit us in areas where we need to act more swiftly.
Yeah, no, thank you very much. That's yes, the Honourable.
So, can you just clarify the nature of the agreement around the national consistency? So, New South Wales is obliged to maintain our legislation in strict compliance with the harmonised model legislation. Is that right?
Yeah, the agreement, it might be appropriate for me to provide the agreement on notice if you like, but the agreement details a process whereby if we intend a legislative amendment to the model provisions of the laws or regulations, that we would propose those amendments in the national forum first and work through the national process to get the model laws changed in the first instance. And then if that is not carried forward in the model provisions, then it's available to us to change those at a state level. It's really the timing of undertaking that process that can sometimes be of concern. So that the question at hand is whether we stay true and positive to that particular agreement and do that in a purest form, or whether we form a view that potentially we might like to move more quickly and we notify the other ministers that we intend to do that, and they might consider the similar amendments in those provisions at the same time.
So I wanted to ask, we heard evidence earlier from the Australian Workers Union around the powers of authorised officers, and it was submitted that South Australia have amended their legislation in relation to that. Did that go through the... So South Australia just unilaterally amended, is that right?
As best I recollect, they made the decision to make that amendment, and then their minister wrote to other ministers to indicate that they intended to do that and that the other ministers might consider that as part of a Safe Work Australia process.
Right, I see. So they've jumped ahead, but it's open to Safe Work Australia and the other jurisdictions to agree to that as the model and then amend the legislation accordingly. Is that right?
Yes, and you might argue that in some circumstances where one jurisdiction makes an amendment to their legislation, that does give an opportunity for us to observe how well that works and whether the model law might be changed in a very similar or different way. So there are benefits to different jurisdictions jumping ahead depending on the circumstances. Queensland have moved ahead on some of the other provisions, so it's a viable option for us to explore.
Can I ask you about that particular provision? Is it do you believe that the issue in dispute was about whether an authorised officer can effectively make their own records on site, take photographs, take readings, bring in equipment for the purposes of assessing whether there's compliance with the work health and safety legislation? Is it your evidence that that an authorised officer doesn't have that power now?
That's as I best understand it, that there is disputation in terms of the entry permit requirements, and that there has been concerns raised between unions and industry about how that applies. Inspectors will get involved in entry permit discussions, but we're not a decision maker in that regard. They tend to go off to the other legislative forums like the
presumably you're the first port of call in terms of disputes. What advice do you provide to disputants in relation to that question, whether you can take a photograph in a workplace of, say, a non-compliant piece of equipment? I mean, surely this is something that's been happening for years. You know, like authorised officers have been entering workplaces. If they can't actually gather any evidence, then what's the purpose of an authorised officer?
Yeah, I understand that there have been disputes between unions and other parties in relation to that. I think there's an opportunity for clarity if the Parliament wants the unions to have that power to go.
So
and
my
seek
question is
information.
really about what do you advise at the moment? Do you say, yes, the authorised officer does have the ability to take photographs, or no, the authorised officer doesn't have the power to take photographs? What is the current advice that's provided by Safe Work in that instant?
It'd be better for me to take that on notice, Mr. Dadden, so I can give you an accurate picture of what an inspector has experienced in providing advice around entry permit. Yeah.
Do you see any obstacles to New South Wales adopting the South Australian provision?
Not from a Safe Work New South Wales perspective. If that's something that everyone wants to pursue, I have shared that I think these tunnelling environments particularly are a particularly difficult place for us to undertake compliance activities and make observations of breaches of the legislation. If a mechanism to do that is through unions, that would be a matter for the government and the Parliament to work through.
Okay. There was further evidence or a suggestion about perhaps looking at the coal services model for the tunnelling industry. Are there any, do you have any comments about the practicality or impracticality of that type of regime being put in place for tunnelling in New South Wales?
As I best understand, the way that's being described is using a process in the coal industry where workers' health information is collected and put into a database and available to those workers across their life or their career. If that's accurately how I'm describing that, then my discussions with
well,
industry...
I think it was a bit further than that. It was also in relation to hygienists being given some statutory force in terms of their directions. So, yeah.
Yeah, I think improved control measures for the health of the workers involved in tunnelling industry is all worth exploring. In my conversations with principal contractors, they have also raised concerns that workers are moving between projects and they don't necessarily have all of the health information available to them as a result of that. So I think there would be support for some sort of mechanism to improve arrangements around how workers can get access to the health information. That seems like a very sensible approach.
Okay, sorry, back to you, Craig.
Abigail, do you have any more questions?
Yeah, I just
Abigail
wanted
Boyd.
to get, sorry, thank you. I just wanted to get clarification on the obligation of PCBUs to notify when they have a silicosis diagnosis with their worker. Is there an obligation to notify Safe Work, or is it just an obligation to notify the Dust Diseases Authority? Or none of the above? What is...
I think, Ms Boyd, in the absence of being able to describe that full process accurately and specifically, I might take on notice the full process so I can come back to you to describe exactly how it works across the full process. I've got some detail on it, but...
Because I know it was reported that there were a number of cases that had not been reported to Safe Work from CPB, and I guess I'm just wondering what the obligations are in the first place, because from our previous questions, when I was asking you about the Section 155, and you were saying it would be really good if there was a direct obligation to notify. I'm just curious as to what the current situation is then.
Yeah, forgive me. I think it's best placed if I take that on notice and then we can map it out for you.
Thank you. Yeah. That would be good. Sorry, I'm just, because I remember, I'm trying to piece it all together, but I remember we had this discussion when we had the obligation for health to no longer notify Safe Work when it came to silicosis cases. And the idea was it was going to go into a federal register and then Safe Work would be able to get it from the federal register. But obviously that's when it's going through doctors and through health, and I'm just curious as to what the obligation is on a PCBU to tell Safe Work.
Yeah, let me come back to you. So doctors have an obligation to report through the National Occupational Disease Register, but I'll need to check the obligation and how the actual process works for a PCBU to notify Safe Work.
Okay.
I go to my next question, if I could please, about the, and forgive me, maybe it's a technical point I should have understood as I've read the material coming through about the term exceedances, and to just probe a bit about this point. There could be, and I'm talking in hypothetical terms here, incident, presumably, in a tunnelling project where there is an exceedance that takes place. I use the word randomly. Let's assume they're drilling through material and they hit a different composite of the material, and it could lead to an exceedance at that particular moment. So it's just happened at that moment. But it's a matter that if the ventilation draws it all away, the exceedance would drop below what may be the requirement for that particular moment in time in terms of the dust. There could be other occasions, I would imagine, whereby from the very start, boring into some material, over what might be many minutes, maybe hours, an exceedance in terms of a level in the tunnelling cavity. So there can be a sort of those type and perhaps some others in between. In terms of when we use the word exceedances, are we using it for one or other of those, or is it a generic term which is just used that there has been an exceedance taken place? If perhaps, I know it's a rather, for me anyway, a technical question, but it may have a straightforward explanation, if that's possible. If Kevin, I'll take it on notice.
No, Ms. Cox might have some more
Thank you.
in-depth information, but the exceedance is an exceedance against the standard of 0.05
Yes.
milligrams per cubic metre over a time-weighted average 8-hour shift.
That's right.
And so usually workers will wear a monitor for a period of time.
Yeah.
They often do 12-hour shifts, so there's a discount for the exceedance number as a result of the 12-hour shift instead of the 8-hour time-weighted average. Where there's been an exceedance based on the time-weighted average, then that triggers an exceedance based on the occupational hygienist's report, which triggers a notification of safe work.
Right.
And if I may, Chair.
No, please, thank you.
A notification may include more than one exceedance. And so for scenarios like you've explained, it may, if it's not, as what was described by some of the witnesses earlier today, not necessarily an absent control, but certainly could be a failed control or an example of what you've just described.
Yes.
And until such time that triage or that assessment is formed and a site verification, that's when that is looked into as well, as so far as what remedial action has been taken in that regard.
No, thank you. So in terms of that formula that was just described, in working out the average over the period with a discount from 12 back to 8, is that determined through what is a procedure, a mandated procedure of the checking of the monitoring equipment that's worn by the individual tunneller? That's what's done? In other words, at the end of their shift, there is a measurement, there is a check done against the reader to see whether or not that's been exceeded. Is that how it's done?
Yes, I have seen a process whereby a circular filter that's in the monitor that's on the worker is taken from the monitor and run through a machine that's name I do not know the name or scientific definition of, which does an analysis of the amount of silica on the filter, and through that amount of silica they can determine whether over the time period of that shift whether there's been an exceedance.
And if we just followed up further, we in our questioning this morning of one of the companies, might have been more than one company, spoke about the matter of real-time monitoring, and it came up in the exchange about the existence of specific equipment that is placed presumably where work is being done to measure in real time what the situation is. So, and once again, if you need to take it on notice, feel free to do so, but presumably there is some meshing of real-time monitoring with what is the monitoring being undertaken effectively by the individual by wearing the piece of equipment. I thought up to now that the real-time monitoring effectively is the gold standard that we all should be shooting towards, so everybody knows that there's, I use the word, a moment of exceedance at a point in time. But there's obviously the two ways of doing this: the monitoring, which is an average, versus what could be what is a machine that has a readout that says there is an exceedance at this point in time, and what that would mean for actually having that formula used to work out the average. I don't know whether you care to comment on that, or it's...
No, as best I've observed, there are fixed stations throughout tunnelling projects that do monitoring of the atmospheric conditions, not just for silica, but they look at diesel particulates. They look at CO2 and other things.
Do they have a readout? Do they of that the workers in the tunnel can actually see the operators or whoever?
I think they have an indicator on the monitor device.
Oh, okay.
And then I've observed where the results are put into the the mess room or similar for the workers to observe the results over the previous period.
Okay. If we just go on whilst I could. With respect to pre-employment checks of workers who wish to commence working in a tunnelling project, it came up in some of the evidence earlier today, at least if not explicitly, implicitly, that certainly some companies, primary contractors and co-contractors, do some pre-employment medical checks and/or diagnosis. And once again, forgive me if I've sort of missed this somewhere in the detail, but is there a mandated requirement somewhere which in fact does require that to be done? In other words, before you could commence in the tunnelling industry, I use that term in a generic sense, your employer, whoever is your employer, whether it's at that primary contractor level or some other contract level, is required to have this medical test done, and if that medical test suggests something, either they have that followed up or have that required to be followed up to see whether or not it needs to be advanced further. Do we?
I understand that tunnelling projects will do a pre-employment check where they get a baseline result for workers in relation to silicosis. Forgive me, I don't know the full detail of how they go about that. I did speak to a worker about the regime that he was a part of, and he indicated that he had been tested, but that from his view, he would like to have seen more testing being done. But I understand there's a risk-based approach, so that people are not overly tested, but are they getting the right access to medical information? It's probably outside the sphere of expertise. Because
clearly, this is where my question, I guess, was primarily going to, about to follow the workers. So say I was a young man or a young woman wanting to have a future doing this particular type of engineering work, tunnelling work, that there'd be an entry point where they started their very first job doing this, and one would have thought that if there was a mandated requirement that there be a medical check, or however one might define it, to an instance that would define the person's baseline at that moment of entry. And then as they followed the work with successive tests, that would be monitoring obviously the medical condition of the individual and being able to sort of identify whether or not there is the commencement of an issue that may manifest, and then presumably as it goes on, that it will become, if I sort of use the word, of greater concern potentially. What concerned me a little bit is hearing from some of the evidence about the fact that it could just be over a long period of time where there's sort of the gradual accumulation, and then there is this moment where it just seems that it can be for some people, you've really got a problem. And of course that's just so undesirable. The ability to sort of at the various early opportunity, and I think in the evidence provided by one of the witnesses today, and I'm not reflecting on the witness, but referred to the type of silicosis called simple silicosis, which I think the implication was it's a very low level, and not putting words in his mouth, not something to be deeply concerned about at that moment. But then there is the other type, which was referred, I think the term used was the complex. I think the word complex was used, complex silicosis. And that's where obviously the rubber hits the road in terms of the red lights going off. So the ability to sort of, at the very moment of entry, do a baseline check, and then each successive start of a job or contract, a new baseline, and that would give you the sort of continuity of the actual condition of the individual with respect to how they're going with respect to this ongoing exposure.
Yes, I think it's entirely sensible that given the nature of this industry that workers are fully informed about the status of their health of their lungs throughout their career.
Yeah.
If there are baseline results and then ongoing monitoring
Yes.
that occurs that could be collected and made available to them at the start of their career, they might consider themselves invincible, and then throughout the nature of their career they wish they had access to the results back at the start of their career. And I think there's an opportunity for us to support workers. Industry is supportive of that being put in place, and I think we're all supportive of workers being fully informed about the things that are impacting them.
Yes, no, thank you for that. Were there any other questions or final questions from anyone? Because we aren't going to hold you back to take you out to the extra 15 minutes, so you've been very, very helpful and we appreciate it. Yeah.
So I'm just looking to get your understanding of difficulties with enforcing the Act. And as I understand it, you said that the tunnelling environment is particularly complex, difficult. There's a lag between reports of exceedances and inspectors being able to inspect. There may be different operations in place. It's lots of moving parts, and it's very difficult to understand what's happening. Other than the different environment of the tunnel, are there other factors which make it challenging for you to perform your regulatory and enforcement role?
I think one of the other factors in my observation has been the nature of the industry and the desire for the culture and the desire of workers to be able to continue working in the industry, given the nature of the work and the specialisation of it. Some of those workers are well rewarded for the work that they do, and they don't want to see themselves being removed from that work and having to go and find other work that might not have the same rewards to it. So I think, as I've observed and it's been shared with me in the industry, speaking up can be very difficult. I've also observed, and has been shared with me, health and safety representatives have shared that often they observe production over safety when we'd prefer to see safe production in those environments. There is a natural requirement to continue with production and keep things moving, but we should never do that at the expense of workers' health and safety. And so the culture and the nature of the industry is important, and I think I heard Ms. Cole's evidence earlier around leadership and culture, and I think that's something that's not lost in your observations if you spend time in and around the industry. That is one of the impediments to us putting in place the best possible safety mechanisms, because often Safe Work New South Wales will receive reports from workers or will gain evidence from workers about breaches and other issues, and this industry can be a little bit more difficult to do that than in other industries.
But is that tunnelling specific, or because they seem to be fairly general factors that you'd expect to find across a range of industries?
They are general factors across all industries. My observation is that it's been particularly acute in the tunnelling industry.
Okay, thank you. That's no more questions, Chair.
Just have one more. Before I draw it off, unless you don't know Roy Roberts, who might have it. The question of the spoil, which is removed from the tunnel, the dust spoil, taken up and deposited in what are normally large sheds called spoil sheds. I think that's the terminology used, or approximate to the terminology used. The spoil then is then removed, normally trucked away somewhere, and disposed of. We haven't quite worked out where that is yet, but we'll probably get to the bottom of it. But with respect to those spoil sheds, they are quite dusty environments as we apprehend, with exposure potentially to the operator of the front end loader who is loading the spoil into the normally B-double truck, and then of course you've got the truck driver himself or herself be potentially exposed if they get out of the cabin of the truck. Just sort of raising it with you, is that something that has sort of been picked up with your works about the issue of the spoil sheds, and it's not just underground, there is this ancillary or associated issue above ground with the whole issue of the dust?
Yeah, correct. Our inspectors look at the system in its totality.
Okay. Yep.
We want to see improved mechanisms with pressurised cabins, with respiratory protection above ground as much as we see below ground. We do see exceedances above ground as well. So
Yep.
we want to make sure all of those controls are in place. Different control mechanisms like the wet style scrubbers that process that dust down underground are obviously better and preferred from our experience. So anything that can be done to reduce the amount of dust available is a good thing. Yeah.
And just final question: do you know where this spoil goes? Is it is that something that has come across your path as you've been poking around asking questions, or?
No, forgive me.
No need to apologise. We will continue our investigation to find out where this spoil ends up. Well, thank you both very much. It's been really helpful. It's been very appreciative you've made yourself available to come along today and further update us with what you did at the start, but also answer our various questions this afternoon. So thank you both very much.
Thank you, Chair.
Thank you.
The questions on notice and any follow-up supplementary questions will liaise through the Secretariat, so thank you. Well, it's just gone nearly 3 o'clock, so I think it's appropriate that we break for our afternoon tea a little bit earlier, and we're back at 3:30. So see everyone back at 3:30. Okay, well, welcome back everyone, and thanks to our witnesses this afternoon in our final tranche, Ms Camilla Drover and Mr David Mullins. Now, both of you, of course, have appeared before the committee late last year, so there is no need to go through the formalities of having you sworn or affirmed with respect to your evidence. So we do welcome you back. It's great to have you back to receive from you some further update of matters that were raised at the last hearing, and other matters you may care to report back on. If you're agreeable with it, I provide the opportunity with an opening statement, and then we've got members, as you know, from government, crossbench and opposition, and we'd welcome the opportunity to ask you some questions. So you okay if we proceed on that basis?
Yes, and we have got an opening statement, if that's
Yes, please proceed.
Yeah. Okay, can you hear me?
Yes,
Yep.
might just pull a bit closer if you wish to do so, but yes, I can.
Hope that works. Yep.
Thank you.
Sounds better. Okay, well, first of all, thank you for inviting David and I back to this committee. We are genuinely interested in supporting the committee, and if there's anything further we can do to address this issue, we will.
Thank you.
As you may be aware, I'm Camilla Drover. I'm the Deputy Secretary for Infrastructure Projects and Engineering, and I'm joined by David Mullins, our Director, Health and Safety, for from our Safety Policy, Environment and Regulation Division. And as at the last occasion, I wish to emphasise the health and safety of our people, as well as our contractors' workforce, is our top priority. We recognise that exposure to dust, including silica dust, is hazardous to workers on many of our projects, including through tunnelling, but not just tunnelling, but also in labs, surveying and geotechnical activities. It's important to note that the responsibility for the health and safety and management and control of a transport construction project is with the principal contractor, and that WorkSafe is the regulator. Principal contractors must abide by work health and safety law to eliminate or minimise the risks of respiratory crystalline silica exposure as far as reasonably practicable, and have a federally accredited safety management system, and that's a requirement of our procurement process. Transport manages risks associated with silica exposure for our own direct employees through the standards, procedures and guidance within our Safer Together safety management system. Transport also requires our principal contractors to have an accredited safety management systems, as well as adequate resourcing to manage the health and safety risks commensurate to the scope of works. Since we last attended the inquiry, Transport is pleased to note that there is an increased body of work and focused on silica and tunnelling within the establishment of the Tunnelling Dust Safety Task Force. The inaugural meeting was attended by the Transport Secretary and demonstrates our commitment and focus to safety across Transport for New South Wales, as well as our suppliers and contractors in the delivery of New South Wales infrastructure. Transport supports the 10-point plan developed by the task force, and we are meeting and working with contractors, engineers and subject matter experts on best practical work health and safety controls and better use of data and transparent access. Transport has also been updating our own respiratory protection program, including systems, documents and online silica awareness training. Whilst these are predominantly focused on our direct employees, they do establish foundations for industry performance. Transport is also reviewing our governance and assurance processes, including contractor management activities and our procurement approach within the current regulatory environment. This work will align the Tunnelling Dust Safety Task Force and assist in providing continued clarity on the roles of WorkSafe as a regulator and our principal contractors, and of course ourselves, Transport as client. The other areas of activity within Transport include: we're working with industry to develop their policy, procedures, risk management, compliance controls and technologies to improve dust safety management. We're also working with the Centre for Construction Safety and Wellbeing at the University of Newcastle to assist with a study into dust within tunnels, providing samples and support to identify which particulate matter represents the highest risk and biomarkers to diagnose early stages of disease and processes to prevent and treat the progression of disease. And also, as part of that, the Transport Contractor Safety Management Program, we're continuing with a project focused at-risk worker management and infrastructure procurement process improvement, so as to incorporate regulated changes and uplift our processes for safety in design when procuring infrastructure construction work. So thank you for the opportunity, and we're very happy to answer any questions you have today.
Thank you very much, Ms. Driver. That's very helpful to set the scene for our questioning. So once again, thank you both for coming on. We'll start. Honourable Susan Carter's got some, and then we'll share it round.
Thank you. Thank you both for being here, and thank you very much for that update. Can I ask you about the work that you're doing with the University of Newcastle? Do we currently have a proper understanding of the health risks involved in tunnelling?
Look, I might get David to help. Look, there has been quite a body of work done to date, and I'm also aware of other work happening in other jurisdictions, for example in Victoria and I think Queensland as well. But David, I might get you to comment on the work at the university.
Certainly. So it's in its infancy. The university contacted us in regard to some eye care funding that's been made available to do some research into this area. And from that discussion, we've looked at our Asiona partnership and Western Harbour Tunnel, and we've identified that that's probably a good site to where they can seek sampling and gain access to the tunnel environment for that work, should the funding go through, should the eye care funding be secured to do that study. So it is at its infancy, but I think it's a good activity in really understanding not just silica, but all the other range of particulates that are in underground environments.
So just to clarify, this study has commenced, or they're applying for funding for it to commence?
Applying for funding.
So there's no actual ongoing work at the moment?
Not at this point. No.
Okay, and the plan would be to use the Axiona site to investigate tunnelling risks at that site?
Correct, on the Western Harbour Tunnel.
And what would this add to our body of knowledge about tunnelling risks that we don't already know?
I suppose the scope of the study is a bit broader than just silica. It's to really understand what else there could be in those underground environments, what other particulates, what other harms could be created. Obviously, this is a fairly rapidly evolving piece of work around silica, but is there something else that we're not picking up? Is there something else, another harm, spore mould, other airborne particulate that we haven't correctly captured, assessed and so forth? But more importantly, in this particular study, it is a little bit regressive in that it's going to assist with diagnosis, early interventions and medical treatment of those who may have contracted dust and disease from a tunnelling environment.
And you've identified the Axiona site as being an appropriate one to be able to get a really full picture of tunnelling risks?
Correct, yes.
Right. Okay.
I think the benefit is it is a real live environment, and it's also the only project that has significant tunnelling left to go in Sydney Sandstone, so that's the other rationale for that adoption project.
So you see that Axiona project as being different to a number of other projects that are ongoing?
Well, it's the last project that we've got of major road tunnelling in Sydney that's left. Okay. So most of the other tunnelling is almost complete or complete.
Right, and there's no future tunnelling projects in the pipeline?
No, they're not.
Okay.
This is actually the last one.
Okay, all right.
So the tunnelling's almost finished on the Coffs Harbour bypass, and it's a different form of methodology. So this has a material amount of tunnelling still to go, and again it's got two different types of tunnelling methodologies. It's both got road header but also tunnel boring machine, so it's a good case study.
Right. So we've heard evidence from other witnesses that one of the challenges of creating and enforcing a safe workplace in tunnels is that it's a very complex environment. Do you have any comments about tunnels' specific challenges with respect to ensuring, regulating and enforcing a safe workplace for workers?
Look, it is a challenging environment because you're obviously underground, but at the same time that actually creates an opportunity to regulate it. So because it is underground, there are many checks and balances. You know, people have to tap in before they go underground. We know how long they're underground for. There's a high degree of monitoring of that environment underground. So because it is, if you like, a closed environment, it also creates the opportunities to manage and measure and monitor that environment.
Then what would you comment has been unsuccessful about the managing of that environment if we're seeing workers who are contracting significant dust-related diseases?
Look, I think the way the environment has been managed has obviously significantly improved in recent times. I think what has driven that is the amount of tunnelling that has actually occurred in Sydney in the last 10 years, both through the road tunnel program but also the Sydney Metro program as well. So prior to that, there just wasn't the level of tunnelling, and perhaps some of the historic practices weren't as contemporary as today's practices.
Have you got any data that you can provide that demonstrates the increasing safety for workers in underground environments, in tunnelling environments?
We've certainly seen examples of increased technology and increased safety practices adopted with time.
And is there data that demonstrates that that has led to a safer working environment for workers?
I just need to converse with David. I'm not sure exactly what data we've got on that, but there would be a lot of data available, obviously, given the level of monitoring.
I understood you to be making a claim that because of increasing experience with tunnelling, we had improved practices, and so I was looking to see the basis for that statement and the fruits of that in terms of increased worker safety.
I think some of the markers that we could point to is just the amount of monitoring that's occurring, the frequency of monitoring, some of the technology and controls that are put in place. As we're probably aware through this inquiry, the lead and lag times for actually contracting silicosis is quite extended. So it's very difficult to get a clear picture of the effectiveness of controls over time, over the longer period. But I think the monitoring regimes being increased, the visibility, the practices on the ground have certainly taken a significant uptick. To find a data point is probably a little bit difficult, other than the empirical activities that are occurring. The outcome data will probably come over time.
So is it a fair summary of your evidence that we are monitoring more, therefore we assume we have a safer workplace?
No, look, I think we're definitely monitoring and putting controls in the environment. But what we probably don't have as much data on is what is the impact and result of those measures on individuals. And that's more difficult to measure, because obviously the workforce is dynamic and it moves between projects, and the workforce moves between tunnelling and non-tunnelling projects and different types of construction projects. So I think that's where we've got the issue. There's definitely evidence that the environments are improving, and there's certainly the adoption of that improved systems for management and technology, but I'm not sure we've got the perfect data set that actually says that's actually adding up to improvements on individuals' health.
So do you have any recommendations that we could consider that would address that issue of what we can be doing so that the regulation is actually assisting to improve workers' health?
I think there's a number of the health monitoring activities probably already in evidence around making sure that when people enter the tunnelling environment from inception, you have those baseline pre-employment health assessments, so we can get those markers and that detail, maintain the consistency of that over the period of the working life of the individual. That will give you the key health data that really need to understand if an individual is being affected. Combined with that, it's not, we don't want to be in a situation where we're canary in the tunnel type situation. We've got to have the proactive monitoring of air quality, and I'd suggest improvements in that space as well. We look at fairly complex equations on how we gather the data, B, analyse the data, and C, then try and make assertions around controls and control effectiveness from that point forward. So that isn't the ideal situation, and the time between collection, analysis and result is quite extended just through the analytical process and the collection processes. So the further we can shorten that, the ideally you want the immediacy of exceedance, big red button, siren, stop work, change your controls, something's going wrong. Unfortunately, we don't have the technology to do that today. But that would be the end state. That would be what we're looking for. And there are incremental activities, improvements in technology that are moving towards that, and I think that this inquiry will help push that even further.
And who exactly is responsible for the analysis?
So in our environments...
well, in the scenario you just outlined.
So it's a certified hygienist. So we make sure that we've got the individuals with the qualifications, experience in those particular technical disciplines to perform the sampling, to make sure that there's a controlled environment, scientific process in the analysis of the material, the collection of the material, and then obviously there's some interpretation and reporting out, making sure that that data is clarified for the end users.
And do you have a view about the extent to which it would be helpful to make that data broadly available for other researchers or whatever to assist in that task of analysis and then development of improved protocols for safety?
I think that the broader, the more people that we can get around this from a technology front, from a manufacturer of equipment front, from the hygiene fraternity, from the health and safety fraternity, from the worker union and everybody else, the more people that have access to that data, the more information we have to really analyse, get sharper with our analysis, and really focus on the most important aspects of control.
So you see no reason why that would be kept within the project? It could be made more publicly available more easily?
Yeah, I mean, obviously it would have to be de-identified,
Yeah,
but I think there would be support from that, from our contractors, the workforce and other stakeholders, because it makes sense. I mean, I have seen an uptick in contractors monitoring their workers' health. And there's been some great examples where they're monitoring for one thing, but they pick up another health issue, and that's provided some benefit for that workforce or that worker.
Can you quantify the uptick that you've seen?
I can't, but I just anecdotally know that, for example, on one site they had a mobile monitoring centre where they cycled through members of their workforce, and that has identified some issues, unknown issues, and that has been a benefit to
And
that
then
workforce.
once those issues have been identified, what improved processes or monitoring or regulation has been put in place to stop those issues reoccurring in other workers?
Often the issues were actually unrelated to their activity at work. The one I'm thinking of, it was actually a heart condition which was identified.
Right.
But that sort of on-site monitoring of workforce, I think, does provide some benefit. And particularly if you look at the demographics of our workforce, they're not always a demographic that goes to the doctor.
Okay. Thank you, Cheryl. Somebody else have questions?
Abigail Boyd.
Thank you very much. We now know that John Holland in 2020 developed this 5-stage hazard management plan for silica in tunnelling, and it was presented to Safe Work. Was that also presented to Transport at the time?
Not to my knowledge.
Okay.
I did read that, but I have no knowledge of that actually.
Because perhaps you could check if there was an actual presentation to anybody in Transport at the time on notice. That would be useful. Because it did talk about, in that presentation, it was suggested that those measures be incorporated into the tender for future projects, and obviously that would be something that would have only related to Transport as the contractor. So it'd be useful to know if you've got any records on that and what the response from Transport was to that. We heard evidence earlier today from Mrs. Kate Cole that Metro has stronger requirements under its contracts for air quality monitoring and health reporting. And she drew the connection between that and a lower rate of exceedances than what we see in Transport. Do you support the inclusion of this, health monitoring and other document sharing as an enforceable requirement in the contracts that you're procuring?
Hey, look, we haven't made it enforceable to date, but we also haven't had an issue with if we've asked for information, we've generally received it, is my understanding. I think the other thing we need to remember is the methodology that Metro uses is quite different to the road tunnels. So they're using tunnel boring machines, which does have a different outcome to our approach, which is road header. And that's generally because of the different nature of the tunnels, the number of cross passages and on and off ramps, etc. So there is a different methodology which will result in a different outcome. But your primary question, yes, but it hasn't been an issue to date, is my understanding. If we want additional information, we would just request it, as opposed to it being a contractual requirement. But we could amend our processes to tighten that if that was thought needed.
I think in our last session with you at the end of last year, there was a statement made by Transport that you haven't seen significant major safety issues of late, and quote, because of the tunnel environment, and it's not just because of dust in the tunnel environment, they are highly managed, regulated environments. We actually often get a better safety outcome overall because it's so managed. And then went on to say we haven't seen significant major safety issues of late. Now that we've seen what we have seen out of the SO52, and we've seen the number of really concerning exceedances, as well as now learning about the numbers of tunnel workers that are already being diagnosed with silicosis, do you see that there is a role for Transport in better elevating requirements for monitoring and ensuring that those exceedances don't happen on sites that Transport is responsible for?
Okay, look, I do stand by my statement. Given the nature and scale of these tunnelling projects, we generally have Tier 1 contractors working on them. And if you look at their TRIFR and LTFR outcomes, they are generally better than industry standards, and that's just because we've got the first tier contractors and the complexity necessitates a whole lot of safety measures that deliver that outcome. That's obviously general safety outcome as opposed to just
I was going to say,
silica.
what is the industry in that context? There's not many
So we're talking about
buyers of tunnels.
Yeah, and I'm talking about overall safety in terms of physical harm to workers. So whether that's injuries to body because they're working in live traffic or electrical interface or whatever. So overall, because they are tunnels and they're underground and the nature of the contractors working on them, they are highly monitored, regulated spaces. But your question about whether there is opportunities for further, was it monitoring?
Yeah, I mean, I just coming back because, your comments there, yes, you can look at industry standard for the harms that we know about, but the problem with dust diseases is that you don't necessarily know what that harm is for a little while. Sometimes it can take decades.
And I accept that.
For it to show up. So if you've got evidence coming in that there are exceedances on projects that Transport is responsible for, you don't currently have in your contracts the ability to sort of call for information, or I guess to impose breach consequences or anything on these contractors. Is that something you would be looking to now sort of build in and sort of take a firmer role on?
I think there's probably two components of it. One is that regulatory breach compliance, prosecutionary path. We have, I suppose, a suite of opportunities to compel and enforce activities from non-conformance, predominantly safety processes, in that auditing processes where we'd look at a situation or a exceedance or any event, a safety event on site. We'd look at it from an investigative perspective, provide a non-conformance and ask for that to be addressed and work through that process. So that is available to us, and if we wanted to, if we requested an investigation to be undertaken, or if we wanted to step in and do an investigation, they're all available to us within our current contract suite. And we do use those from time to time. So if we work through a process with an exceedance, we will follow that through to ground, get the information that we need, and satisfy ourselves that there is a control or a focus on improvement in control across the board. And apart from that, looking at specific instances across the board, the industry as a whole, or across our principal contractors, working with them to try and elevate above and beyond wherever we can, where it makes sense to do so. So things like VersaFlow, they were instituted prior to any requirement being enforced upon them. That was an industry initiative. We got together, had discussions around the challenge of silica. We talked about the different segs in the work group, what the exposures were, what we could do to do it, and from that discussion came the institution of VersaFlow. And that wasn't a small task in itself. So that wasn't through contract, it wasn't through a compliance process, it was through an improvement process, a safety improvement process. That makes sense.
Sorry, you wanted
Yeah,
to say.
and we had 2 workshops last year, February and July, just on how we could improve the safety in tunnels, and it wasn't just to do with silica, it was broad safety. So again, it wasn't in response to any legislative change or any new requirement. It's just the right thing to do, to continually work with our contractors to see that we can adopt continuous improvement as we go forth in tunnel.
So if information came to you that there were a lot of exceedances at a particular site, or if there was, or there was information coming from new research or other things to say actually this would be a better way to do things in order to keep workers more safe, is there, and it's not something the industry wants to do, is it something that you could proactively require? And I'm thinking of, for example, if you've got workers doing 12-hour shifts, which is an extraordinarily long period of time anyway for something that's often quite a physical job, but we know that 12 hours in an environment that's got that high exceedance is obviously going to be much worse for a worker than 8 hours. But there's a cost to the company of bringing on more workers. So is there a capacity for you to look at that and say, actually, we want to impose an 8-hour contract, an 8-hour day under these contracts? Do you have that sort of flexibility?
So look, a couple of things. The principal contract is responsible for the safety on the site, and Safe Work is the regulator. But as a good client, we will always try and influence our contractors to ensure that we get a safe outcome. But I suppose we haven't had to enforce anything to date because we've actually been working very collaboratively with the contractors to strive for better safety anyway. In terms of work hours, the threshold for exposure for workers is already moderated for the amount of time they spend in the tunnel. David can give me the exact details around that. So there are already some measures in place to address, the length of exposure, and accepting that those shifts are long for tunnelling workers. But we haven't had a specific request, to change the durations of shifts and therefore had any discussion about what that might mean in terms of commercial arrangements.
A last question and I'll hand on. Has a contractor ever come to you and said, look, we think that we need to impose this new thing in order to increase safety, but it will cost us so much more that we actually need to adjust the contract? Has that ever happened?
No, not in my experience. Maybe David has some experience. And I think the VersaFlow is a good example because that was something that was instituted, to my knowledge, during the contract, so it wasn't necessarily from day one, and there was no request for additional funding or anything. That was what they had to do, they felt, to protect their workforce, to meet their safety obligations.
There's not a specific. There is from time to time with the legislation changes on the 1st of September, there is some variation claim coming through, which is at cost, and we will review that. Is it reasonable? Is it practical? Is it in line with the legislation and so forth? That does occur when there's changes in legislation mid-contract. Obviously, contracts are a written point in time, and there's changes in frameworks, in requirements over that time. So they come down to a commercial discussion generally, but by and large they get paid where it makes sense, where it's aligned with the legislation and so forth.
Thank you.
Thank you. Yeah, just got a couple myself. Mentioned in passing in an answer to an earlier question, I think a collaborative project with Acciona. Is that was that right in regards to the tunnel?
So
Yes, the Western Dump.
Acciona is the contractor
Yes.
for the second package of Western Harbour Tunnel.
Correct. And did I mishear what you were saying about there was some collaborative work being done with Acciona, or some project that you were working on with Acciona in terms of some aspect of?
Yeah, there's a couple that Acciona have initiated. So the tele-remote management of the roadheader.
Okay. Yeah.
So that's one, and then also the work with Newcastle University, utilising that site as a location to sample.
So just as a follow-up, could I ask you, who do you deal with Acciona in New South Wales? Is there a general manager for occupational health and safety that you're dealing with, or are you dealing with some other person located elsewhere? If I could ask that question.
So we deal with the general manager, the project director, safety leads on the project.
And they're located in New South Wales?
They are, yes.
Yes. Okay. Yeah.
Yeah, so we deal with them on many levels.
Yeah.
There's a number of initiatives that Acciona have proposed and are trialling themselves. The tele-remote is one of them. The boot wash for the cab,
I think it's been mentioned earlier.
that was actually, I understand, proposed by one of the workers and adopted by Acciona. And then, as David said, we'll also adopt that as a case study site for this proposed work with the university.
But those individuals you mentioned, their titles, they're located in New South Wales, so they have ready access.
Absolutely.
Yes.
Yeah, that's good.
The project team is all located here.
Thank you. With respect to the issue of the title of principal contractor, we had a company in earlier today, Geller, who is a company you'll be familiar with, and they describe themselves, I'm sort of paraphrasing them, but a smaller operation within the tunnelling industry, but obviously co-join or join with other businesses as part of a project. And I was trying to tease out with my questioning about, was there any subservience that the smaller operators had vis-a-vis the principal contractor? Because what I was trying to tease out is that, is it a sort of a vertical requirement? So you've got the tier one operator who is the principal contractor, and that everything really flows from that down, so to speak. And by nature of what is the practice or the requirement, everyone falls into line, so to speak. And the answer that came back was that it wasn't quite like that. It was more collaborative, and that they seek to obviously have synergy working together. There's not competition in that sense. But I'm just wondering if you're able to answer from your knowledge, is it the case that the principal contractor really sets the pace, and what flows from that must by definition sort of flow down the line in those simple terms?
Yeah, okay. So commercially, Geller, for example, is often part of a joint venture.
Yes, that was the example here.
So, so they might be 50-50 with another tier one contractor. So commercially, they are sharing 50% of the risks, the profits, and the downside on a project. However, when a JV comes together, they usually decide which safety system they will adopt for that joint venture.
Right.
So they may decide that it's not going to be Geller's safety system, it may be their JV partner's safety system. And often that's perhaps a JV partner that perhaps has a longer history in Australia or New South Wales. Not always, but the JV decides which safety system they'll operate under. and that will be the safety system that will be adopted for the project. So
That-
they're
that-
slightly different concepts. One's a commercial coming together, and one's which safety system will be operating.
That's very helpful because Perisher thought there was a tension and I just wasn't quite sure from the answer back. No disrespect to who was answering the question about the nature of what is the consistency down the line in the context of what we're talking about, occupational health and safety. Just my final question. It was described in, and it was also by the gentleman from Geller, talking in general terms, I have to say, but I took it as what is the practice, that obviously there is a long lead-up time, starting from the point where, I suppose, let me say the end point is where I guess they sign onto the contract with the government to do a project. But this primary contractor, or who would be deemed, if it all comes to pass, the primary contractor, and these other contractors who are going to be in this joint contract, that there's a lot of nothing out of things over a long period of time to work out whether or not this whole plan of a joint project is going to be able to be brought to fruition and iron out a number of things to bring obviously their tender proposition forward, ultimately for consideration. My question is, during that lead time, or perhaps I'll ask this question first, is that your understanding that there is sort of a quite a lengthy deliberative process which is entered into before we ultimately get to a sign-off? That's taken as a given, I presume.
Yes, look, I might just explain. Our practice is to do a market engagement process well before we come to procure a project.
Yes.
And the reason we do that is so that we can share with the market the nature of the project that's coming. They can understand the risks, they can understand where they want to participate, they can inform the way we might package, the way we might, what form of contract we might use, and how we might share those risks. But it also helps them to decide where they want to go for that project.
Of course.
And therefore that will help them form joint ventures, etc.
Yes.
They'll need to have formed a joint venture by the time we issue an expression of interest, because that's actually when they say, look, we're interested, and by the way, here is our team. It usually takes, often 3 to 6 months or perhaps even longer before we actually shortlist and decide which of those that have expressed an interest and teamed will actually go forward through a tender phase. And that can take up to a year depending on the complexity of the project. And during that procurement process, the tender phase, we will ask for plans to be submitted. Now, we don't necessarily ask for all the plans to be submitted, but key plans around safety we will ask during a tender phase. Then one of the contractors will win, or one of the joint ventures will win. But before they go anywhere near starting on site and breaking ground and tunnelling, it often takes them about a year to actually develop their design, detailed design, but also in parallel get the approval for the construction environment management plan and all the other plans that sit below that. So that gives them a lot of time whilst they're doing that detailed design to actually finalise the exact methodologies, the exact nature, and all the plans and controls they're going to adopt for that delivery. So they do have a reasonable amount of time. They've done some of it in the competitive tender phase, but they have that period post-award to finish, finalise, and make specific their plans for their actual detailed design that they're going to lock in and then go and build.
And just follow it through, then I'll pass on to someone else. So with respect to then tunnelling projects, that at that point where there is this first engagement with yourselves and the potential business entities co-jointly wanting to come forward who've showing an expressive interest, up front you're placing information before them, perhaps even expressing them what are going to be minimums required in the area of occupational health and safety, so they can be appraised of that straight up from the very start?
Well, absolutely, but even beyond what we might prescribe, they have to have a federal accreditation for tunnelling, and they will know what the Australian standards and all the other requirements are well before any project,
Yeah, of
because
course.
they're generic, if you like.
Yep.
But
No, I
then
was
there'll
just
be
trying to-
specific things, and they will tailor those plans depending on the geology, the particular methodology, and a whole lot of other project-specific and site-specific constraints.
No,
And also they'll need to respond to the planning conditions.
Of course.
So it's one of the reasons why we don't like to award contracts until we have planning approval, because we need to know what the planning conditions are to make sure that the contractor is bidding and basing their pricing on those project-specific planning conditions, which include environmental and other
Related matters,
requirements.
No, that's very helpful. Are there any other? Yes, the Honourable Chris Rath.
Thank you for your evidence so far. I was wondering if any consideration's been given by Transport New South Wales to using independent hygienists, if that's, or if it would even be possible to use independent hygienists on specific tunnelling projects.
Look, I think they, perhaps.
I can talk to that. So within the safety function within transport, we have a group that's specifically focused in on health, and within that group we have hygienists, qualified hygienists. So we can draw on them to provide us with verification, checking any technicalities on site. So generally, when we have a project set up, we'll have a team of safety professionals working on that project in lockstep with the project team. They're safety generalists, but we have the specialists centralised, and we can draw on them to help out with any interpretation. There's always hygienists embedded in these projects. So when the hygienists get together, they will review, discuss matters, talk about their testing methodologies and so forth, particularly with the recent changes in September. Obviously upticks in education, standardisation of the awareness training, those types of things. There was a lot of involvement between the transport embedded occupational hygienists and those that are embedded within our principal contracting groups, just to make sure we're all working in lockstep and all sharing best practice as we step through those changes.
So how do you...
And there are other instances where we've engaged an independent hygienist ourselves.
Yeah.
We did that on the Rosal interchange when we had the asbestos issue. And I know the contractors themselves also engage independent consultants, companies to provide that service to them.
And with contractors, how do you ensure that the contractors actually enact the recommendation of the hygienists? Like what? Because we've heard some evidence that occupational hygienists might have their safety recommendations ignored or not being actioned entirely.
I don't have any evidence of that, but David?
Yeah, I'm not aware of any specific examples. Suffice to say that some of my team members embedded in projects work in lockstep with the hygienists and the safety teams within the in the tunnelling environments, and they're cross-referencing and validating data information, issues, and improvement activities daily.
Yeah, okay. And does Transport do like audits?
We do.
Yeah, so to ensure that
Yes.
the recommendations are being implemented as well. Okay.
Thanks, Deputy Chair.
Yeah.
Well, if there's no others, thank you very much, and early Mark. But listen, appreciate you coming along for a second time. It really is much appreciated to provide a further update on matters, and we do appreciate that and appreciate all the good work you're doing. So on behalf of the committee, thank you very much. And that brings the hearing in conclusion. Oh, sorry. Are there any questions taken on notice? I'm not sure. We'll double check. Any questions on notice or supplementary questions, we'll through the committee secretary liaise with you. So thank you very much.
Fantastic. Thank you.
Thank you.